Gentlemen, welcome to the Environment and Community Committee meeting of the Toowoomba Regional Council for the month of July. So this meeting is open to the public and also live streamed. So I'd like to thank those who are in the room with us today and also acknowledge everyone watching via Council's social media channels. So good morning to everyone present. I'd like to open the meeting by acknowledging the traditional owners, so I acknowledge the Aboriginal parties whose songlines traverse these lands we meet on today, the Western Waka Waka and Guyabal and Jarowair peoples, and pay respects to their elders past, present and emerging, for they hold the knowledge, rich traditions and bold ambitions of Australia's First Peoples. Apologies, anyone heard Councillor Taylor? Okay, so...
There's a lot of traffic issues. I know she's having trouble getting in. She sat at four sets of lights yesterday trying to get in, so that could be the issue.
All right, so we'll just proceed along that line. So Kevin Jeffries is standing at the moment, so GM Nick Hauser is just a few moments behind. Here he is, grand entrance. Good morning to General Manager Nick Hauser, but he'll come forward. But I think for our first item, councillors, we do have the review of Local Law 1, Administration 2011 and associated administration subordinate local laws. So Kevin Jeffries will introduce this first item.
Okay, morning councillors. The local law review that was before the last committee, we have had the opportunity to go through that in detail through an information session, and I do thank all councillors for their participation and the feedback that you've given us. We have addressed a number of the issues that you had some concerns about or wanted clarification. We did provide a further update about what those changes looked like and what would be included in the local laws, which we have incorporated and made those changes. As we have outlined, this is a very early stage in the process, so the next step is to get state approval for the local law and then to go out and advertise the local law and the subordinate local law for public comment. One of the issues that it has been introduced into the local law is the move on requirements, and it'd be fair to say there's some reservations about that from some councillors and what that means. As I said previously in the information sessions, those powers would be very seldom used, if ever used, but it was raised by the Ombudsman's Office through a case in the Gold Coast about not having some sort of requirements in your local laws. That being said, it's up to council to decide whether it stays in or it stays out. My advice would be if there was to be concerns about it, then take it out in totality rather than trying to amend it, because trying to amend it would give us some powers and not others. It's in or it's out would be a far better way to deal with it. Apart from that, I don't think there's a lot of issues. A lot of it is trying to reduce some of the red tape, making it easier for people to do certain things, provided they meet certain conditions. And some of the examples we gave to you were a shopkeeper at the moment can't utilise the front footpath to display goods. The only thing they can do at the moment is if they're a restaurant, they can use that for outside dining. But a shop selling clothes or shoes or whatever can't have at the moment displays on the footpath. Now, the local law changes that we're trying to introduce allow that to happen, provided they meet certain conditions. They don't block the whole footpath and those types of things. Some standard conditions, they can do it as of right. So we are trying to reduce the amount of red tape. One of the questions that you raised around the time frame, the 12 months, we're taken out. We agree with you. If somebody wants to apply earlier, so be it. For some of the big events, that will be the case. Most of the small ones, it's not. So I think that's about all I have to say.
Thanks, Mr. Jeffries. Any questions, councillors? Councillor Hara Sullivan.
Thanks, Mr. Chair. Kevin, can you just explain to me again where the origin of the need for the move on laws came from? Can you just run through that again? The strengthening of those.
Yeah, it was raised, and Grant will be able to speak. I'll get Grant to speak to that.
Thank you, Kevin. Thank you, Mr. Chairman, Councillor. The origin of it was that the Gold Coast, exercising its common law powers, actually purported to ban somebody from using their facilities due to his conduct. And the Ombudsman took a dim view of the way that they just did that, relying on their common law powers, and suggested that they really needed and would benefit from putting some more specific provisions in its local laws. So, yeah, all I'm doing is suggesting that it might be a positive move if Council wanted to do the similar thing here, but it can still rely on the common law to do those things. It's just not expressly in a local law.
Follow up?
For the follow-up, so I presume in consultation with staff, like at the pools and the libraries and things like that, that this is something that the staff has been wanting to have more robust powers around what they can do. Is that fair to say?
Not well, apart from the consultation with Kevin in the regulatory affairs area, I certainly haven't gone and spoken to staff at the pool as to whether this is something that they would love to see happen. We've just made a suggestion amongst the management group at Toowoomba Regional Council that this is something that might be worth putting to the council. The consultation hasn't been undertaken with the public or with staff widespread as yet.
Happy with that? Any other? Councillor Shine?
Just to clarify, to your knowledge, there's been no incidences that have arisen in the past in Toowoomba which would necessitate the introduction of this local law.
I'm not aware of any, but Mr. Jeffries has been here much longer than I have.
No, there has been some instances in the library and Milne Bay swimming pool. I can't give you a number, but it's very small numbers. I think it's 2 or 3 incidents.
And was it not the case that the police could have been called to that type of occurrence?
Yes, they can, yes, and sometimes they are. We've had incidents, I mean the police powers, they can move them on, but they can come back, and that's the trouble. We'll, whether it's in or it's not in, we will still deal with the issues and use whatever powers we have, common law powers. This, as Grant was saying, just strengthens what council can do, considering the criticism that the Ombudsman gave around the Gold Coast example. At the end of the day, if it's not in there, we will have to rely on our common law approach and the police assistance.
Okay. Any further questions? Councillor Von Hoff?
Thanks, Mr. Chair. No questions, but comments, if we're at that stage.
Take comment? Yeah.
So I have circulated the my proposed changes to item 7 with regard to the move-on powers. And Wendy, do you have those at hand? I feel particularly strongly about this, and it's something that we have talked about, but I think perhaps with some further articulation.
So, sorry, Councillor Von Hoff, just speaking with the CEO. So, do you want to move an amended motion?
I would, yes, thank you. The copy was sent to Wendy
Okay. So, do we need a seconder for that?
and circulated with.
So, do I have a seconder? Councillor Shine. Okay. So, Councillor Von Hoff.
Thank you, Mr. Chair. So I find these laws problematic, and I think that other councillors will also find them problematic, but perhaps for different reasons. For some councillors, these laws will be objectionable because they limit liberties, and there's a potential for them to be misused. And I've said that the problem with laws aimed at the baddies is that sometimes they have unintended consequences, and improperly used, these laws could have a harsh impact on minority groups, the homeless, individuals with mental illness and other vulnerable groups in our community. And then for other councillors, these laws will be objectionable because they grant move-on powers to authorised officers, and this represents an overreach of local government powers and responsibilities. Is it necessary, I ask councillors, for local government to act in a function that's currently carried out by police? TRC currently relies on provisions under common law, as Kevin was saying, and I thank him for those comments, and for Grant for his advice, to regulate the behaviour of people at locations owned or controlled by Toowoomba Regional Council. These laws potentially are a dreadful responsibility, in my opinion, for TRC employees. We want our employees, in my opinion, to call the police. That is a very simple message. Move-on powers are very complex, and they're used with the utmost discernment and discretion, even by police. Expecting our staff to act in a function carried out by police who undertake years of training is unreasonable, and we should expect that staff will feel a duty to act on these new responsibilities and powers, perhaps even choosing not to call the police because they feel that they need now to deal with matters themselves. Lastly, I'd say that these powers exposes us to civil lawsuits and community concern. And for our employees, we can reassure them that unlawful behaviour is not tolerated at any Toowoomba Regional Council owned or controlled public spaces, and moreover that employees should feel supported by us councillors in contacting the police when they experience unlawful behaviour. And they should also be encouraged and reassured by a heightened awareness amongst the police and judiciary of microaggressions, stalking and harassment and the like, as well as sexual predation and assault. These were two of the examples highlighted during our earlier discussions. So I would just say to my fellow councillors, who even if you were previously okay with the amendments, just to ask yourself two questions. The first is, are they necessary? And the second is, does it make sense? On balance, are the risks sufficiently balanced against concerns? And if your answer to either of those questions is no, then I would suggest you shouldn't be supporting the move-on powers being included, and that's why I've moved this amendment.
Okay. So do you want to? Do you want to read what your amended motion?
It goes over sort of 2 pages, but basically it is that the.
Move it.
Oh, sorry, Wendy. We almost had it there. Basically, it's that the direction to leave a public place is removed. And I note what Kevin and Grant were saying about the exclusion notices, and I think that to reassure our staff, that is an important provision, and actually that could even be strengthened. And if there has been a conviction of a person, a conviction of an offence at a public place, one of our public places, then that's also been included there into section 2A. So a proposed exclusion notice may only be given to a person under this section if that person has been convicted of an offence at a public place. So then we strike out section 2, B, C, and then we move into section 3 is maintained. No changes there except for part 6C, and we refer back to that strengthened exclusion clause 32A.
Okay, so there's quite a bit of info in that, obviously. So your motion is to remove those sections that you've highlighted.
Those changes that are there, yes.
Okay, so that's the motion. So there was a second. There was a seconder for that. Do I have a speaker against the motion? Sorry, question, Councillor Carl.
A question through you, Chair. Couple perhaps. First one has, I note that Councillor Von Hoff has circulated this. Has these proposed amendments been circulated to the management to actually have some time to decipher this?
Yep.
I guess my next question is through you to probably the manager. Is he, or the general manager for that matter, are they confident in the police's ability, albeit 2 to 3 offences over a period of time, whatever that is, confident in the police's ability to act in a timely manner given their potential workload at any time?
Good morning, councillors. I think I might ask Mr Wilson to respond to that question, Councillor Carl.
Councillor Von Hoff's proposal was certainly circulated to me. I don't know, I think Kevin and Nick may have seen it and formed a view about it. I did have a discussion with Kevin just before the meeting started, and from a personal view, my recommendation would be you either leave the provisions as proposed in or take them out entirely, because I wouldn't really be recommending that council makes the alternative proposals that Councillor Von Hoff is recommending that you make. I don't think they add a lot of value to the objective trying to be achieved, and they do have difficulties, which I have outlined in a letter of advice that's been circulated separately yesterday afternoon.
I had a couple other questions. Councillor McMahon?
Are we speaking for and against, or?
I think,
I had a question to my
Sorry, Councillor Carl. Yeah.
to my second one
yes.
about police availability in instances where they're required. It is a council issue. Pardon me, Councillor Nancy. It is a council issue if it occurs on council property.
I'll defer to Kevin because I'm not sure of how well the local police respond. So.
Yeah, and I realise it may be a bit subjective or whatever that word is for you use for that question, but it is a very real likelihood in having dealt with other matters pertaining to policing. There is a known workload at any given time for law enforcement in our community, as there is with many other lead functions in a community.
To answer your question, yeah, we work closely with the police for a number of issues, and we are at their availability of staff to attend to some of the instances that we have. A lot of the times it's to do with animal management, dogs, dog attacks, or serious dog attacks. We had an incident during the pandemic down at the Animal Management Centre where we had a person that was refusing to leave the Animal Management Centre. We called the police, and the advice we got, and understandable, was we were seventh in line for their response team. So they weren't going to get there anytime soon. So we had to call security guards and other to assist us for that person to move on. So they have a workload like we do. They can't attend some of the things they do not see as priorities. When we have animal management issues to deal with, we have to wait to deal with that till they have available resources. So it's not something we can do automatically, unless it's a very serious dog attack where there's injuries and other issues to be dealt with. That's the nature of the business, I'm afraid.
Thank you.
Okay, so I do have a motion with a mover, obviously, and a seconder on the books, but does anyone have any other questions before I move? The Mayor.
Look, if you don't mind, there's a lot of things that we don't know about this particular matter, I think. I think we need to get a bit more understanding. I'm not prepared to vote on this today.
No, I'm not.
I don't know the full detail. There's a group that I wouldn't mind having in the room when we have a discussion around, that would be the local police. How they interact, how they see these laws, how they would work with us to make it better. And look, my personal view, I would very much like to see this opened up for a bit broader discussion.
Mm-hmm. Okay, so we'll take that as a comment. Or do you want sorry, Mr. Mayor, would you like an answer?
Well,
can I ask Mr. Wilson or?
For my colleagues to have a bit of a think about.
Yep. Councillor Summerfield?
Yeah, at the risk of bringing up something which would appear trivial, I raised it in the workshop, and that is on page 28 in the dictionary. We still have a caravan with no wheels heading west on the Warrego, being towed by a vehicle. So what I'm saying to you is a caravan is something that is fitted with wheels, not that it's not fitted with wheels. If we could remove that again, please.
Yeah.
Yep, noted, thank you.
Hang on, so, yeah, Councillor?
I don't know where I'm at. I don't know whether we're debating or what we are doing. I don't, and I'm not prepared to vote on this. I'll vote this down because I think everyone has rights, and I agree with the Mayor. Yes, it was circularised. I don't know about anyone else. I haven't had time to sit and look at it at length, and I've got Mr Wilson's yesterday afternoon and had a look at it, and I see his reservations as well. And I'm happy to take, everyone has rights. The public have rights, and they have rights to be able to be in a place without being disturbed by people doing the wrong thing, and our staff have rights as well. So we always worry about the rights of the person who's doing the wrong thing, and we should. But we also need to remember that everybody has rights, and I would like to see this properly discussed and properly developed. And if there is an obvious need for it, and I know I've had incidences out at our business where we've needed police and they haven't come because it's very low on their radar because they're just like our people. They have got a lot to do and they have to prioritise what they do. So at the end of the day, if we do need that level of protection, I suggest we have another talk about it and we get people in here to advise us. And I think we should keep in mind everybody's rights, not just the people doing the wrong thing.
Okay, is there any other questions? Is there any questions on this?
Just a comment in relation to what's been raised by the Mayor, which, from my point of view, these are serious matters, and if people are unsure about where they stand on it, where they should stand on it, then further consideration is always a desirable thing, and to put it off for some time would be fine from my point of view. And I'd certainly go along with that if we are to move a postponement of this for another day.
Okay, well, I'll go back. So the original mover of the motion.
Thank you, Mr Chair. I'm so happy to hear that people would like to examine these in greater detail and really digest what the proposal is here. And so I'm happy for it to go to a discussion so that everybody can really unpack what this detail is. If we can speak with the police, fantastic. And Councillor Taylor, I'm so happy to hear that you say you're concerned about everybody's rights. That is exactly why I could not propose an amendment to this. So I'm very happy to postpone if there's consensus for that, and we really go over this in some finer detail and include the police as the Mayor suggested and really dive deeply into it.
Okay, I just might get a comment from Mr. Jeffries.
Thank you. Through the Chair, what I've just to try and assist, what I would suggest is that if you want to have those sort of discussions, that's great. And personally, whether it's in or it's not in, it's not going to change our roles significantly. What I would suggest, though, is you take the move on requirements out completely, and that allows you to have further discussion out of the proposed amendments to the local laws. Take it out, have those further discussions, have the police and whoever else, and there may be some feedback that comes from the community because of what was proposed. Have those discussions. We can always come back and amend the local law and go through this process again for that particular issue. That would allow the rest, which is positive changes, to carry on, go through the process, public consultation, while we debate this more serious issue.
Councillor Carl?
Through you, Chair, would it in fact be more prudent to let this lie on the table until such times as I feel there'd be great value and benefit, as the Mayor suggested? We have the other key stakeholder in the room, a representative from the police, in joint discussions about how we would propose to deal with this in the future or not. But leave it lie until such times as those discussions have been had, and with Chief Counsel obviously involved, and senior management. And why I raised those questions, because I intently wanted to hear what the managers and roles and feelings were. They're the people on the front line with this.
Councillor Summerfield?
I just wanted clarification. I thought Mr Jeffries wanted us to approve some type of local law today so that they actually have a law that they can govern under, and that we remove this particular segment totally so that we can then work through it at a future workshop. And to me, I think that's a really good suggestion.
Yeah, and that's it, isn't it? Yeah, 100%. Councillor McMahon? Sorry.
Yeah, look, I agree with the sentiment around the room. Perhaps it's a dissenting view. I can't obviously speak for Councillor Von Hoff's proposed changes today, even though there's a lot of work gone in there. I think that the view of Mr Jeffries and Mr Wilson, that we either put it in or we don't, rather than change it, is valid. But while it's a very much dissenting view, I feel adequately equipped to vote on the original motion today. I think I've had enough, been brought up to speed and feel confident on these powers, and we're not talking every day. I liken it to being a small business owner that has an unruly client and asks them to leave, and I don't think that's an overreach of powers for our senior staff in our swimming pools, etc., to be able to do on rare occasions. So I'm certainly of the opinion that I would be happy to vote for the original motion in today's meeting. I don't think I need another information session.
Thanks, Councillor McMahon. I'm a bit afraid of going into debate here, but is there any other further questions? And then I'll ask for a motion. So we don't have a motion on the floor. So that one, the original one, has been removed. Correct? So I'm right on that. The original motion that you put forward, Councillor Von Hoff's off the table. We'll think about that. I'll come back to you. A question?
Mr Chair, all I was saying was that we could approve all these local laws, just take this one out.
Yeah.
It's pointless for everything. I think that's what Mr Chair...
Yeah, and that's what I'm hoping we'll get to.
We should do. We can go forward and do that now. And Councillor McMahon, I agree with your point in part, but I think we need to, as a council, if we're passing something, we all need to be completely cognisant of what we're doing and have our... I think it's better if we go away and have a talk about it and come back and amend it. And I haven't moved a motion, but we have a motion sitting on the table. But I think that it'd be very silly for us to let all these local laws sit on the table. When we only really have a concern with one.
Yeah, thanks, Councillor Taylor. And that's what I'm trying to get back to. But I'm happy if there's any other questions that wanted to be asked before we get. You got a question, Councillor Shaw?
Well, yeah, I do. I also have a reservation about the quantum of the penalties involved here. Typically, they're 50 penalty points, which equates to about $6,500, I think, from memory. And just to my mind, that sort of a penalty is just over the top, particularly when you're dealing with the people that are most likely to fall foul of a law of this nature are usually, the down and outs, don't have a quid to their name. That's a couple of dollars, or do have mental health issues. And I just think that something, half of that amount would be more appropriate. And that's, that goes throughout the whole of the local laws. It's an extensive document. And I don't know where those figures have come from, whether it was the Gold Coast who suggested it, and it's a different community to ours, of course. I personally, if we're going to, unless Kevin can indicate that there's a pressing need, there's some changes that have occurred in our society in Toowoomba over recent times to necessitate the introduction of these laws as a matter of urgency, then I think we could let the whole thing lie in abeyance, hear from the police and hear from other people as well who might have some expertise in this area, or we feel that we might benefit from other experts, academics, for example, who've done research into these areas, might better inform us to make a decision that's most of us will be happy with in the future.
Might get Kevin Jeffries to respond.
Mr Chair, I think it has to be deterrent, and I think
So,
that's...
yeah, I think if we allow Mr Jeffries to answer the question.
Well, the issue is if you take that section out and move on, the penalty goes as well. Penalty is 50 penalty units, but if we issue an infringement notice, the law says it's only equivalent to 5 penalty units, and I think I provided you information on that. Obviously, if it went to court, the magistrate has the ability to introduce a higher fine, but as for an infringement fine, which is what council officers can do, we are limited to 5 penalty units. So the penalty unit is $133.45, so it's only about $600. But if you take that section out, that penalty goes, so that takes the concern of Councillor Shine away as well until we get the time to review it again.
Thanks, Kevin. Question?
The question, Kevin, following up on Councillor Shine in regard to timing or a necessity to do what you've suggested, which was to move a motion excluding that out of the local law number 1 and moving all the others. Is there a necessity to do that, or can we hold the whole report over?
Through the Chair, my advice to you would be to... the other changes we are keen to see introduced, because most of those are making it easier for the public, and in fact it's making it easier for us. There's less work to do. If people don't need to have a local law approval, can meet the standard conditions, we would like to get on with that sooner rather than later. The example I gave you around shop owners not being able to use the footpath in any form at the moment to display goods or sell their products, or if they do, they're doing it illegally, and we don't follow it up for most of the case unless the whole footpath was blocked. This allows those activities to happen. We've reduced the requirement for local laws for signage. It would be great to see those things introduced, because it's a benefit to the public and it's a benefit to council that we don't have to deal with so many of those issues. My advice would be take out the move on provisions, have further discussions about that, and adopt the rest of this to go out for consultation. There's a further opportunity to review that once you see the public comments that may come back regarding the amended local laws, while you still consider the move on provisions.
So basically, Mr Chair, that's basically the motion would be that council adopt the laws excluding the move on notification to go out to public consultation.
It's just going to
basically the motion. So you've got a motion on the books with Councillor Vonhoff at the moment.
That's what I mean. So I've got to get back to that. Yeah. So that's what I mean. I'm getting back. We'll go back to we'll go full circle. So
Thanks.
just with that, so councillors, obviously there's a lot of info on that we've digested here. So we do have an original motion on the book that does have a seconder. So I'll go back to that original mover and.
Thanks, Mr Chair. So I will amend my amendment so that that council approves or endorses local law number 1, excluding part 7.
Okay, so council resolves to. Okay, so Wendy's just putting that up. What's it called?
They are. They're all. That's all. So everything else will be. So everything else, all of the red tape cutting, all of that sort of great stuff, community event planning, terrific, but not the move on powers.
So council will just work up this amendment.
Number 1 in amendments.
So that means that we'll take that one out. As I said, we vote on the remainder. The one that we've had a lot of discussion about today will come out for further consultation with police. So we'll follow that through there. So we'll just get this finalised. Sorry, Mr Mayor?
Small addition that we come back together and get a better understanding of that particular section of the...
Yeah.
Absolutely.
These laws are living documents. They can be changed rapidly. When you think about it, and I've written a few things down here, there's a whole lot of people who can help us in this, not only our council staff, occasionally have breakfast with some of the people who clean the streets. They've got a lot of information about the behaviour in the community. 3 a.m. and 4 a.m. of a morning. Private security, the police, all those things may help inform us, just set a basis for the next step. But I would like to make sure that in that resolution that goes forward, there is a very clear indication that we're going to discuss.
I agree.
Okay, so I'll just leave that with the CEO is just working through this at the moment. So do you want an extra point in the motion for further consultation or info? Okay. Okay, so we just, so you'll see that before you councillors coming together. So once we've got that up there, we can see that we've got the consent of the mover and the seconder. You happy with that? Okay, so that motion there is before you. So we see the addition there of the second item. So the mover, you're happy with
I am, thanks, Mr Chair.
the seconder? You
I'm just unclear about what it is, the motion that you're now talking about. Which one is it? Number 2, is it?
so 1 and 2.
1 and 2, just hold on.
So council resolves to propose to make local law number 1, 2020 with the removal of part 7, which is the general powers of direction. So that's the first part of the recommendation. The second part of the recommendation, that council review whether part 7 general powers of direction should be included in an amendment to local law number 1 at a future Environment Community Committee meeting. Question?
Nothing to do with that, though.
Right.
To do with another subordinate law.
Okay.
If we're going to that, which I'm happy to. In our discussion, we spoke about, it's probably a little different to what we've just been discussing for half an hour, but around horse-drawn vehicles. We added that in there. And I just wanted to be rest assured that on page 550 of 783, which is local law 1.18, that the prescribed activity, it's been shortened quite a lot from what it was in our first report, section 2, and it refers to commercial vehicle identification label as being, that's where they're issued into those areas. And I just wanted to make sure that that still includes that, because when we came to council the first time, there was a list of probably about 15 different vehicles. Now we're down to that. So I'm hopeful that that subordinate local law number 5, parking, includes that. I haven't checked that, so maybe it's a question on notice.
Mr. Jeffries, do you know the answer?
Yes, through the chair, what you were presented with at the with the first set, unfortunately, that had not been updated. That had been updated and amended, so some of those items did come out, and it was unfortunate that we provided the full list. So there is criteria, and it is covered in the parking local law around the types of activities. And yes, if we did have a horse-drawn operation that wanted to operate, then we could cover that under the local laws that we have and issue them with the label for that activity. If it wasn't a label, then we would give them a local law approval. So we would cover it either way.
So you comfortable?
Different to what we had first off.
Okay, so question?
So just a question. So when this goes out to consultation, because I've got a couple of trivial things here as well, following on from our workshop, which haven't been amended, and I'm just wondering, rather than, in the interest of time, we would be actually able to do a submission once that consultation period opens, and we would be advised when that consultation period's open, so we can actually have input at that point?
Yes.
Yep. Thank you.
Yeah. Okay, so the motion is on the book, so I've got to move it. Seconder, Councillor Shine, you're comfortable with the amendment? Any need to go into debate? Okay, so I'll put the motion to the vote. Those in favour? So those against? No? One. So carried. Thank you for everyone that. So we'll continue to work on that moving forward. We move to item 4, councillors, and it is the request to name parkland at Clyton as Leopard Ash Bushland Park. I think Michael Condren will present on this one. And I'll get GM Hauser to give a quick overview.
Thank you, Mr Chair. Councillors, I'll just give a very brief overview. I think the report's quite comprehensive and happy to take that as read. But essentially we received an application from Friends of Escarpment Parks requesting consideration to rename a piece of natural bushland that was reverting to its default park name. We've undertaken consultation in relation to that proposed naming. The proposed name meets the criteria of our parks naming policy, and we recommend we rename that parkland as Leopard Ash Bushland Park as requested and submitted by Friends of Escarpment Parks.
Any questions, councillors? Councillor McMahon.
Or questions first?
Any questions? No?
I think it's pretty good.
Yeah. Councillor McMahon?
I support the change. I went and drove and had a look at this park. It is quite small, but in the middle of suburban Clyton, and happy to acknowledge the work that Friends of Escarpment Parks are doing in that park. There's a few feeder boxes and breeding boxes put in there and a few kind of tracks through it, but it is a very small park, but happy to support the name and keep this little bit of nice little rainforest in the middle of suburbia happening. Thank you, Chair.
So happy to move? Is that what you're saying to me? It's seconded by Councillor Taylor. Any debate? I'll put it to the vote. Those in favour? Carried unanimously. Thanks, Michael. We move to item 5, councillors' reappointment of town crier and honorary ambassador. So Nick will give us an introduction to this one as well.
Thank you, Chair. Sorry to interrupt. I don't believe this conflict, but I just thought I should declare that the town crier and I have a bit of a history, both on the same team and on opposing teams in numerous football, soccer games throughout the years. And while I don't believe this is a conflict, just wanted to make the chamber aware.
All right, so we're comfortable with that?
Would you like me to put it to a vote? Or?
No? Does anyone have any concerns with that? Right. Happy? Okay. Over to you, Mr Hauser.
Thank you, Mr Chair. Councillors, again, I think the report speaks for itself. Mr Houth was appointed as our town crier in previously in 2017, and we seek to make a reappointment of Mr Houth for a further period.
Any questions? Mr Councillor McDonald.
No question. I'm happy to move.
Right.
With strong support. I think Kevin's done a great job, and happy to move it.
Okay, do I have a second by Councillor Taylor? Were there any questions? No, there isn't for debate, I would imagine. I'll put it to the vote. Those in favour? So carried unanimously. Is that it? That brings to a conclusion, councillors and ladies and gentlemen, the Environment and Community Committee meeting for July.
Councillors, welcome to the Finance and Business Strategy Committee meeting for July. Welcome to the Mayor, councillors. and particularly acknowledge Councillor Shine as Portfolio Leader for Finance and Business Strategy. Of course, this meeting is open to the public and will be live streamed, so welcome to all of those tuning in across the world. I'd like to thank you for your attendance here today and appreciate the passion that you have for this particular area of council by way of deliberating in an open and transparent fashion. I would like to begin, councillors, by also acknowledging CEO Brian Pidgeon and our General Manager Anne-Marie Ryan. Thank you, Anne-Marie, for coming along today, and I know that we'll have other presenters as they come in through the course of the sessions. But can I firstly begin by acknowledging the Aboriginal parties whose songlines traverse these lands we meet on today, the Western Waka Waka, Guyabal and Jarrawa peoples, and pay respects to their elders past, present and emerging, for they hold the knowledge, rich traditions and bold ambitions for Australia's first people. Item number 2, councillors, is the attendance, including apologies and leave of absence, of which there neither, so we'll move straight to item number 3, councillors, which is the Controlled Entities and Beneficial Enterprise Powers Policy. Anne-Marie, you are here. Is Grant available? Grant's not here yet. He's the author of this item, but we'll work through it, Anne-Marie, and see what questions we may have if we need to refer to Grant when he arrives back. Thanks, Anne-Marie.
Good morning, councillors. So the executive summary of this report, this policy provides a framework for the governance of beneficial enterprises, including council's controlled entities. And if you go through the report, you will note that there are several Queensland Audit Office recommendations for the development of this policy.
Councillors, no doubt you've had great interest in reading this, and of course it's come to council primarily as a result of Queensland Audit Office, as the General Manager has identified, and those that will have been at the most recent Audit and Risk Committee will note that this has been mentioned, and previous councillors will also note that this has been mentioned, that we need to have a policy in regard to control entities and beneficial enterprise powers, and this is what this has come to council for. You'll also note that the next item is in regarding one of those entities, and later on in the economic development meeting we've also got another one of those controlled entities. So this document is a very important one. This is the draft, and if we propose to put it through next Tuesday's meeting, will become enacted on, which will then feed into the controlled entities and beneficial enterprises as well. Are there any questions, councillors, in regard to this? Councillor O'Hara-Sullivan.
Thanks, Mr. Chair, and thank you, Anne-Marie. I just note with the from the Audit Office comments, so section number 8, comments concerning existing entities, and it says, the first board of directors was originally decided by TRC. Subsequent boards are appointed by directors at each AGM. Note, TRC may wish to revisit these provisions as it does place a lot of power in the hands of people who are not necessarily members nor patrons. Most other TRC entities have formed as controlled entities, allowed TRC to decide who constitutes the board. So where are we up to with that?
Sorry, we just missed that first little section just when Grant was coming in the door there.
So that's, it's section number 8, comments concerning existing entities.
Section 8. What page is it on the board books?
It's on page 650.
650, okay. That'll help.
Specifically concerning TSB.
Oh, TSB.
Oh, this is delving down into those examples, is it?
Yep.
Yeah, okay. I think these are comments concerning existing entities, and we'll probably cover off on that this afternoon as well, I'd imagine. But Grant, would you like to make comment in regard to item 8, which is in the policy? As I read it, it was examples showing maybe areas that have been raised as concerns?
Areas of concerns by the Audit Office about the appointment of directors.
Through you, Mr. Chairman. Councillor, the dot point is, it's not a matter that was raised by the QAO, that last dot point on the bottom of page 17 of 21 of the draft. That's just simply something that I've commented on that Council may wish to consider in future in terms of rebalancing how TSB operates or should be structured.
I beg your pardon, I misunderstood that, but it is something that I think is of grave concern, that the way that the directors have been appointed in the past. So
Yeah.
where are we up to in terms of making changes to that?
Sorry, the answer is it's just my comment that you may wish to consider that. There has been no deliberations that I'm aware of about changing that. So this is the first opportunity that the councillors will have had to consider that issue.
I suppose I'm just seeking direction as to what's the process from here?
I guess where Councillor O'Hara-Sullivan might be coming from is having consistency across these entities as well, how board directors are appointed, and perhaps that's something that this document, Mr Wilson, could be included in for consideration. Is that where you're coming from, Councillor O'Hara-Sullivan?
I suppose I'm just, whether it's from the CEO or whatever, like what's going to happen from here?
Sure.
The whole tenor of this document and framework is that all of these things are up for discussion whenever councillors see fit to question whether or not things are working as they expect to. So if councillors wish to pursue that question with the CEO, it's simply a matter of indicating that they'd like some further meeting to discuss those issues. I'm sure there are possible differences as to how you may wish to structure TSB as opposed to how you may wish to structure the Empire Theatre, for example. And they are nuances that and they really are things that, had this document been around years ago, the council probably would have adopted the detailed business case approach that this document recommends that you do in future. And you could always re-examine how you wish to structure any of these options at any time.
So I guess what I flagged at the start was that TSBE will be, there's a discussion around TSBE this afternoon. So maybe through but through that deed of agreement is where items like that can be put in, because the operating agreement for Empire Theatre, in fact, follows this one. So there are options for us to include those within that framework, because there may well be differences for each group.
Thank you, Chair.
Oh, great. Yes, Councillor Carl.
Yeah, through you, Chair. I'd in fact like to see this included as part of this overarching policy for all entities, not as part of a discussion about the entity. After all, we're deciding what is appropriate, and I note your comments, Chair, about consistencies across controlled entities of council, which I'm an advocate for, regardless of the organisation. Can I go back to page, just bear with me. Page 3 of 4 of the report, or 631 of 783 in board books.
631?
31 in board books. Down the bottom, and it makes reference here of the CCC's suggestions or recommendations. And my question is, are we looking to implement this, or is this just a suggestion at this stage? I would have thought that it would be probably more than it would be a very wise suggestion. In the interests of transparency, that a normal level of scrutiny to which this council is responsible or open to should be applied to the same entities that council own, given the fact there are public funds that these entities are supported with. And further to that, my reasoning for it is, if we didn't have this entity, we'd be doing it anyway, and it would be open to freedom of information requests and public scrutiny under the normal regime of council business. So it's irrespective whether it's a third party, wholly owned entity, subsidiary, whatever you want to call it, or council business. So I would have thought that this would be a normal course of business to actually, at this point, include those recommendations in this policy.
Thanks. Mr Wilson, you might comment on that. I think that's probably the crux of why we're here, to be honest. Work through that.
Thank you, Mr Chairman. The references to which the councillor refers, and perhaps I should just read them out, is that in Chapter 5 of a report called Culture and Corruption Risks in Local Government, the Crime and Corruption Commission made certain recommendations, and the one to which the councillor refers is that all controlled entities of local governments be deemed units of public administration, which is what a council is referred to under that legislation. And the objective of the CCC was firstly to bring those entities' conduct within the oversight of the CCC, and also to subject them to the right of information laws. This paper doesn't purport to mandate that you decide that question today one way or another. It simply poses it as an ongoing governance question that will be of interest to council, and it will probably become of greater interest depending on which direction the state goes in relation to accepting or not accepting that recommendation from the CCC. If the council were inclined to subject all its controlled entities to, for example, the right to information laws, then what that would entail is that the council would probably have to take a greater role in actually record keeping those entities' records on a day-to-day basis to ensure that it's also compliant with the Public Records Act. So there is an administrative burden to take into account there. I haven't purported to try and do any number crunching to come up with what that might entail in terms of additional resources. From a philosophical perspective, I could understand that councillors would probably be quite happy to accept that these entities should be subject to these laws, but they don't need to be, and the issue there is you need to balance that against the increased costs that the community would have to bear, because really either we've got to pay these entities enough money to be able to manage these obligations themselves and respond to right to information requests, or the council makes its resources available to help them out as and when needed. So again, this paper, I'd just like to accentuate that this paper is an overarching governance framework which the QAO have called for the council to adopt, and I think it's a good idea for the council to adopt it. It's not intended to answer all those minute questions. It's not designed to sort of give you the panacea for all ills that some might believe exist with some of these controlled entities. It's really just a decision-making framework to guide your future decisions.
Thanks, Grant. Follow-up?
Yeah, if I may. Wilson, regardless of, as I stated, regardless of whether it's a controlled entity or we in fact would do this type of business in-house, it should still be subject. If we were doing it in-house, we'd be doing it anyway. And we would have those burdens, as you say, but in the interests of transparency, and I don't see how one could actually legitimately argue against the case of transparency around public funds being expended on these entities, it should be a matter of course, whether it's, and this leads me to the thinking that we really need to be careful about what entities we propose or think we would like to create in the future, given the level of rigour that needs to be put in around governance and transparency and the right to information. That should be normal course, normal business as usual. Doesn't matter whether it's an entity or not. Because we would be doing it, if it wasn't an entity, we would be playing in the economic development space to a greater level anyway. Therefore, our books would be open to and subject to the normal rigours of scrutiny that we as local government are subject to. I would like to see this included as, if not in this policy now, well, I think it should be, it's a recommendation from a peak body that is there to design, there to protect the interests and reputation of not only council, but the interests of the public as well. So whether it's in now or I think, Mr CEO, a matter of urgency and priority that we have some discussion around moving forward with this and how it's implemented. If we were to wait for the state to make a recommendation on everything, I could name a myriad of sections of council business where we do not wait for state to make recommendation, and it's considered normal par for the course or normal business in council matters.
Thank you. Unless you wanted to make comment on that, Grant, I'm more than happy to take that as more as a comment at this stage. Councillor Summerfield.
Thank you, Mr Chair. I'm just wondering, has this policy been workshopped at all? Because I don't recall it coming through, but I may have been away.
This is the first time we've had the policy come to council.
Thank you. And as per meeting last month, it was requested that policies come to councillors for a workshop beforehand so that we fully comprehend what we're voting on. And I personally couldn't vote on this today because I don't fully understand the implications for any of the entities that we have. And so for me personally, I'd like to see this workshop so that we fully understand what it may or may not mean for council and also the entities that we oversee.
Okay, well, I'll continue some questions, but you might think of a proposed motion, Councillor Summerfield, to defer, subject to a information session, perhaps. There are a couple of other questions, so I'll just go to Councillor Shine first, and while Wendy perhaps makes notation of that deferral.
No, thank you, Chair. Just to clarify, this is a recommendation from the CCC. You know, just because the CCC recommends something, it doesn't mean that it should be. It's holy writ, in my experience. It recommends that these entities be deemed to be units of public administration. Is that within the power of the council to do that, or is it a state government legislation?
That it would require the state government take that step. We could, for example, as part of our operating rules, insist that they make all their records available so that we can manage access to their information in the same way that we do. That's another way of doing it, yes, but it's not up to us to deem them to be that. It might be worth commenting that the state have had some time to consider those CCC recommendations, and the only thing I've seen emanate from the department thus far is a quite recent recommendation that their financial records of these entities be made public, and that's still a current discussion paper, so they haven't actually proceeded to do anything more with what is in that recommendation.
Not within our power.
No. Okay. Are there any other questions, councillors? We've indicated that there may well be a deferment of this for further discussion, and there is a recommendation there, Councillor Summerfield, that's up on the screen. This matter be deferred for consideration at a future Finance and Business Strategy Committee meeting. You have your, sorry, Councillor Antonio.
Entities of this nature, of course, are subject to the Audit Office, and in the same way that we are, is my understanding.
Correct.
Are we? I've got no problem with further scrutiny, but how much of this is absolutely necessary if we're already subject to the Queensland Audit Office?
And I guess that could be the questions that are raised in the information session, and we can work through there. Councillor Summerfield.
Thank you, Councillor McDonald. Could I just suggest that we add at the end of that, following an information session?
Sure.
Thank you.
Okay, there is a motion there. Do I have a seconder for that motion? Seconded by Councillor McMahon. Need to go into debate on that one? I hardly think so. Those in favour? Unanimous. Thanks, Wendy. Thanks, Grant. Probably don't go too far away. Similar sort of thing could happen here. Not too sure, because this item number 4, councillors, is the draft Empire Theatres operating agreement, and in fact we have the author of the first one 20 years ago, and the co-author probably, or contributor 20 years ago in the room. So that makes it interesting as well. But Anne-Marie, would you like to introduce this?
Yeah, happy. So, councillors, you will note that this agreement is the version that has been developed in consultation with the Empire Theatre directors and with the Chief Executive Officer. Proposes to use, without any further changes he may see fit to make from time to time, to allow the Empire Theatres to continue to occupy and use council assets. And you will note that this one is for noting rather than for adoption, councillors.
Can I just ask a question in regard to that, Anne-Marie, in regard to why it is for noting and not adopting? Is there a reason for that? Is there? Well, we're not quite at the final adoption stage.
That's
Still.
the answer.
Right. so
We're still reviewing.
So the reason that you need it today, though, is to continue discussions with the Empire Theatre. Is that correct?
I suppose the main reason for tabling it today is it just had synergies with the earlier item on the agenda.
I'm reading some tea leaves here, Mr. Wilson. Maybe there's some synergies around deferring this one until we cover off on the one prior. Is that a feeling in the room that perhaps we should do that? Like someone like to move?
Well, Mr. Chair, is that necessary? As the General Manager has mentioned, it's still undergoing negotiation. Would we not be better to wait until we have what has been negotiated to come back to council? And then maybe what is the reason for wanting this to be received today?
Perhaps I could answer that, Councillor. It is, as we've mentioned, just for noting, these agreements, the content of them would usually and has historically been decided by the CEOs. This is really just to advise the Council that over the last 12 months or so, the Council has been asked by the directors of the Empire Theatre to see if we could rejig the content of this agreement a bit to take on board some of their concerns. It's probably fair to say that we've had some lengthy conversations with the directors, and the end result is there isn't a lot of change. So it's more par for the course, but we've gone through a process of consultation with the Empire, and if the Council is happy to note this today, the CEO can continue to get on with and negotiate whatever changes he's happy to make in future. It doesn't need to come back before Council, but if you would like me to bring the final version back when we...
The final version for adoption?
We could.
Have you had a comment on that?
I'm happy with either way. I can do it under delegated authority and finalise those negotiations, or you can. I can bring the final version back for council's final approval. Either way, I can do with it delegated authority or full council decision.
Okay, councillor. So I'll go back to the first comment. If we've deferred the one prior, perhaps, is there a willingness to defer this until we get that settled? We've got to this point, or is there a willingness to continue on? So open for someone, if they'd like to move deferment, more than happy to put that on the table, or more than happy to continue through the process of noting this so that conversations can continue.
So just a question, Mr. Chair, through you. I did probably not phrase it well. This is for noting. We're not asked to approve this or anything else. We're just asked to note it, whereas the other is quite different. I don't see the reason for a deferral of this.
Okay. So therefore, councillors, it is for noting only.
Happy to move.
Happy to move?
Second it, thank you.
It's quick. Okay. Moved by Councillor Summerfield, seconded by Councillor Carol Taylor. Those in favour? Those against? You're right, Bill. Unanimous. Okay, thank you. Item number 5, councillors. This one probably won't have as much interest in it, perhaps. Proposed show or show holiday dates for 2021. Item number 5. Pretty straightforward. The recommendation is there before you. Anne-Marie, did you want to elaborate further on that? It's more of an administrative action, actually. Moved. Councillor Shine.
I presume I don't have a conflict of interest, bearing in mind it's nothing to do really with the running of the show itself, is it?
No, this is about the show holiday. So
I just raised that because I was excluded last time.
okay, right, my view is there's be nothing to do with this particular decision. Someone like to move that motion? Councillor Melissa Taylor, Councillor Megan Harris-Sullivan second. Those in favour?
Sorry, what's the motion?
To have 2 holidays, basically.
Well, I just wanted to
You had a question?
question about.
Question, okay. Well, we've got a mover and a seconder at this stage, so
The question is that it appears to me that the Toowoomba Show holiday appears to cover other areas where, other townships, for example, where individual shows are also held at different times. And my question is, do those places have an extra holiday, you know, on the Friday? And is that appropriate that they should be included in the Toowoomba area? Probably a good reason for it, I don't know, but it just seems odd to me that it seems desirable to me that if you're going to the Pittsworth show, the Clifton show, that there should be a holiday in those areas for those people to go to the show, to support the show.
Mr Chair, can I make a
to
comment?
go to the show for their show. Well, the difference is that these are royal shows. These are at a higher level of a show, as far as show hierarchies are concerned. Once you get to that royal show status, there are different levels of public holiday provisions.
So for Pittsworth, Clifton, wherever, they're not official public holidays?
No.
Is that right? Okay.
That's right.
Can I make a
Councillor
comment?
Taylor?
Thank
Sorry,
you, Mr Chair.
Sarah.
As a former secretary of the Gundawindi Show Society, small towns don't actually want a show holiday. It just gives them another weekend, and a lot of people decide to go away. So this is a good way. They still get their public holiday, but it's on a Thursday, which doesn't back up to a weekend. And the small communities do support this. I'm very aware of that, spoken with the show societies, Pittsworth and Crow's Nest and others. They all support this. So it's gone through, everyone, you know, they get that holiday and they can come to Toowoomba and they can still go to their own shows and without a large proportion of the community travelling away for a long weekend.
Thank you. We have moved by, who did move that? Councillor Melissa Taylor, seconded by Councillor Harris-Sullivan. No other question? Debate?
I'm voting yes.
Oh, you're happy to move? Okay. Those in favour? Motion's carried unanimously. That had more discussion than I thought, actually. Item number 6, you never know with these things, do you? Item number 6, councillors, is the new policy. Well, in fact, it's the policy 2.09, acceptable request guidelines for councillors. We have had a session on this and it's come back, as I recall. General Manager, would you like to
I'm happy to pass over to
pass over
Mr.
to
Wilson.
Mr. Wilson? Okay, just to introduce and take questions.
Take questions.
Were there changes, Mr. Wilson, from the last time we spoke as councillors?
I think the only thing that may be worth noting, Mr. Chairman, is the commentary within the report itself under the heading Issues, Risks and Responses. It's not essential for councillors to adopt this policy. The report indicates why you may form the opinion that it's advisable to do so, and the main aim of it is to ask that the councillors be encouraged to direct their requests in the first instance to GMs so that they don't overload the CEO with the amount of requests that are directed to him. And really the policy just speaks for itself. That's probably the only introduction it needs.
Okay.
There is a provision in there that might be worth noting that has really nothing to do with acceptable request guidelines, so it sits a little uncomfortably with this policy, but it is something that was touched on last time, and that is at 3.6. There is a protocol in there about councillors, when they're having deputations and meetings with constituents to discuss any matters, that this policy will require that they advise their general manager or managers, and it's then up to those people to try and ensure that an appropriate officer is available to assist the councillor and to assist you in making public records, which the CEO is obliged to keep and make under the Public Records Act.
Okay. Councillors, any questions, comments in regard to this? Councillor Carroll?
So I don't know, that's what I've always done, I just haven't, I suppose, when I've met with someone, I've always, particularly in the portfolio, I have always made the general manager or the executive manager aware that I was doing that, and I've always had, even if I'm meeting with someone on a planning thing, I've asked the planning people to provide an appropriate staff member to be at that meeting. I suppose the only thing I'm not doing is, I don't do, and is recommended here, is to keep official notes, I suppose. But if you do have a staff member with you, they will keep those notes anyway. So I've done that in my whole local government career, because early on there was a he said, she said situation, and it's for protection of all, and I think it's probably a very worthwhile thing to have. And I don't know how other councillors feel about it, and I'd like to know, but I will continue to do that, regardless of whether it's in here or whether
it's in there or not. Okay. Thanks, Councillor Carroll. Councillor Nancy, then Councillor Rebecca.
Thank you, Mr Chair. And I too have always felt that, but I've just been thinking about scenarios, and there are times when we are invited by a resident or business to come and have a look at something on site, and that's not something I've ever involved officers with. I've just been asked to go, and I'm sure a number of other councillors around the room have too from time to time. And so I haven't engaged an officer as well, because it's just been, I've been asked for me to just go and have a look at an issue or whatever. So I just wonder whether in that one, and thanks for pointing it out too, Grant, I just wonder if that one in the second line, instead of saying they must advise the relevant general manager, they should consider advising. I wonder whether it shouldn't be in there. It's a reminder that if we're meeting, you know, certainly if I'm having an official meeting here at City Hall with anyone, I always include officers, because I think it's beneficial. A, you've got somebody there as a witness, but B, also they can provide additional information. But I just wonder whether instead of must, that's a very strong word, whether they should consider advising for times when we are actually out and about in our region, large region. It's not just meetings at City Hall that this would actually refer to. It actually includes meetings when we're out and about. So I think we have to be careful here.
Yeah, that's a good point. Can I also perhaps suggest that the next line, which says so that they can ensure an appropriate officer is available, because you could well have the same situation, that an appropriate officer may not be available.
Yeah.
So maybe it's that they can consider having an appropriate officer. Probably gives a bit more freedom. Have you made a note of that, Grant? That's probably a reasonable suggestion, I'd say. Is that it for you, Councillor Summerfield?
Thank you.
Okay. Councillor Von Hoff?
Thanks, Mr Chair. So I agree with your comments and Councillor Summerfield's comments, because I'm just running the scenario that, say I go to Oakey for the day, and I call in at 5 farmers, different farmers, and then I have lunch at a cafe, and I talk, they're water conversations. People come to me and we have water conversations. Not all of that can be, I don't know, there's a spontaneity to what we do, and that's part of our jobs when we are consulting with the community. So I think that those wordings that you and Councillor Summerfield just brought up would probably do the trick for me.
Happy with that? Okay. Councillor Carl, did you? Yeah. And then Councillor Carl.
Yeah, whilst I agree with those comments, but you look at the words pre-arranged deputations, representations or meetings with constituents to discuss their concerns, applications or complaints. I wish to take a slightly different view. And the acid question we need to ask ourselves, each and every one of us, is if we weren't a councillor, would we be discussing any of the aforementioned matters? And the obvious answer is no. And in the interests of public record, transparency and the protection of both staff, councillors, constituents that there is some sort of record. Now, I myself, having read this document and the recent request from state government around submissions to this, will from this point on, if I do happen to have a meeting with a constituent in the cafe, will be making a personal note and passing that on to the relevant part of council as a discussion that I had regards whether it be water, planning, doesn't matter. In the interests of the Public Records Act, once a councillor, always a councillor is the old saying. So I would go further to ask council to consider, and at for a future discussion, Mr. CEO, that council consider not an arduous but a rather streamlined process of a meeting records or register. And that is what defines a council meeting. I've outlined probably my personal views on what is a council meeting and what isn't. There's pretty not much that wouldn't fall under a council meeting, but there's different levels of how we might record that. For these that are mentioned, pre-arranged deputations, representations, meetings with constituents to discuss, etc., absolutely, we have every opportunity and it should be must. And the reason why I say that is because it actually helps set tone and culture for those lobbyist groups or individuals that try to have an exuberant influence on elected members around the table here, and there becomes a systemised or a formal approach to how topics get on the agenda for discussion to council. And the other reasoning for a meeting register or log to be kept is that any councillor should have open and transparent access to be able to ask questions about any meeting that took place with any of their colleagues or any members of the public in the interest of transparency. So, and I'm not suggesting it be an arduous register. It could be as simple as, and we sometimes informally do it now, and that is the staff member in a meeting takes notes, but it could be a simple time, date, meeting topic, those present, issues discussed, directives given. And then there is a true and accurate record open for scrutiny if need be at a later date. And it takes away the innuendo of he said, she said, and the possible not so nice things that come from the grey areas of who was at a meeting and who wasn't. I'm suggesting that, Mr. CEO, I'd ask councillors to consider the possibility of a simple meeting register or request be held or discussed, the notion of that be discussed, and we set some guidelines out for that as a supplement to this 3.6.
Councillor Carl, there are a couple of other questions, but we're almost approaching debate, but this is only one element of it. So I've let it go to that point, but I'll take some other questions because they may relate to that point, and then we may revisit that area, because it might be that we actually separate and have a 3.7 that perhaps covers off on both areas, because there's a spontaneity, as Councillor Vonhoff mentioned, and then there's pre-arranged. And they're two separate things, if you like, but they can cross over. Councillor Carroll?
Chair, because whilst in part, if you have a look at the first part of this, pre-arranged delegations, meetings that are pre-arranged, it's very easy, but there is spontaneity, and I think also sometimes it's just as reassuring to have another councillor with you. And if you're visiting out there, sometimes you do. And I'd hate to see it so that we nearly need a secretary, a personal secretary, to be able to handle what we do. And you know, if we go out, if I'm walking down the street here, I often meet with somebody, have a cup of coffee with them, and I just put a diary note, met with so-and-so, re such and such. So I'd hate to, if it's an formal yes, but I'd hate to see it such that councillors were spending more time on governance and requirements rather than actually out there on the ground, knowing what's happening and dealing with our constituents. So I'm a bit in both ways. I think certainly I've always been a stickler for having staff. We also need to be careful to remember that we're taking staff time too from their day jobs. So I don't know how we manage to, I'd hate to see it get, yes, everyone wants to have transparency, and yes, we should all know what's happening, but don't make it too much that we can't be a councillor and be on the ground with who we're representing, because other than that, we'll be taken away from the people, and that's not what we're after either.
Sure. Councillor Shine?
No, thanks. Just on that, my reaction is one of amazement compared with the role of a Member of Parliament, where confidential discussions are held all the time. Apparently that's not desirable based on the interpretation of Councillor Carl. My question though is that under this, it's my reading of this, it's for the council officer to make the notes or the record in line with the Public Records Act, not for the councillor to do so. Is that right?
Yes, that's right.
Well, I've read it. Thanks, Councillor Shine. Okay. Any other councillors got questions in regard to that particular point? And then, Rebecca, and then...
Thanks, Mr Chair. So on Councillor Shine's point, a question then to Mr Wilson or the General Manager. Would that be overly burdensome or and take them away, as Councillor Taylor said, from their day-to-day business?
As in, if as Councillor Carroll was mentioning, the additional workload, if you like, the admin side of things. I guess that's...
Prearranged, it's easier.
Prearranged, you can organise it, but
the appropriate, sorry to speak out of turn.
No.
You can get the appropriate person there with the information, as Councillor Nancy mentions, and also taking a few notes, and you need to be guided that you know, and that's easy, but it's the spontaneity thing that, and even then, I think the onus is on us to then say, well, you need to come in and have a meeting.
Well, that's exactly. So, Councillor Vonhoff, back to you.
Thank you, Mr Chair. And I also wonder how people in the community would feel about this and their reluctance to meet with us in some cases, if they felt that, and whether or not they felt that they could be completely open in their comments with us if we had to have a council officer present, and if they felt that there was note-taking happening during it. I think that it would change the atmosphere and the tenor of that conversation.
Yeah, it's a valid point as well. I'm just flagging, perhaps Councillor Carl will go back to you now, but my personal opinion, I do exactly the same, and other councillors would. You make notations if you meet with someone and follow it up in that appropriate fashion. So maybe it is just that particular one where it says they must advise the relevant general manager, the changes there. So you still advise, that must. So that covers off on that transparency type of thing as far as, but actually being in attendance at the meeting is sometimes just completely...
It doesn't work.
You can't do it. So there may be a 3.7 in here, Councillor Carl, which is that councillors meeting constituents without prior arrangement make notations in their own diary and contact the appropriate general managers, because it may well be in a particular different area than your own. So, and perhaps maybe contact the appropriate general manager and portfolio councillors.
That would work.
And that would then cover that transparency. It's a spontaneous meeting, you just make a note of it, and then, which I think we do now anyway, to be honest. It's just putting it in writing. Councillor Shine?
Just a matter of information for me, because I'm familiar with it, but do we have a good understanding of what the Public Records Act requires us as councillors to do? I can't remember in our induction, Mr Wright, that or any other occasion where we've had any real tuition about that. Some people seem to know a lot about it, but I don't.
We had a fair working over at the tail end of last term, I think, in regard to this area. It is changing, but Mr Wilson might comment on that.
Perhaps I could add to that, Councillor. There is a planned session with the information management people within council who are planning to come back to you and provide a bit more education around that. I think in a nutshell, the Public Records Act places all the responsibility on the CEO to make sure that the council makes and keeps adequate records of its operations. So it doesn't impose any personal obligations on councillors at all. So
it's quite reassuring.
The other mechanism that we have, councillors, which we use regularly, is pathways, which will actually document a lot of those concerns as well. But I think adding that 3.7 may cover off on Councillor Carl's concern. And I must say I do it now anyway, so it's no different to what we do, which is meetings that aren't pre-arranged but just happen in the course of our job. We'd make a note of it and make contact to general managers, the same as what Councillor Shine's done the last few Fridays when meeting constituents, and put that through pathways. No different. Councillor Summerfield?
Thank you, Mr Chair. So I just wonder, given that we're argy-bargy about all this, plus there's the additional stuff coming from planning, I think you just said, Grant, perhaps we should defer this until we sort it all out. Or do you want to amend it here and now? It's up to you.
Oh, well, if there's not much more to amend other than this, were there any other major concerns?
Clause, what does the extra clause say?
Did you put something up there, Wendy, by any chance? 3.7? I just can't read that there.
So, Mr Chair, could I just make a comment? By putting something in pathway, should almost, if there's a complaint, wouldn't that fulfil that need to put that, to let the, because that goes to the general manager?
Probably does, yeah.
If it's not in, say I get a complaint about water, and I put it in there, and it'll go to the water portfolios and the general manager. I think that's how it works, isn't it? Through you to the CEO.
It is, yeah.
Right?
Pathways works.
Pathways makes a record, that's right.
Yeah, but it also goes to the general manager of that.
They wouldn't, if it's a council law, they will be, that's right.
Yes, thank you.
Was making it in a new process.
So we're actually doing it when you put something in.
Yeah, you probably are, aren't you?
Sorry, I guess that's my question. If what we're having, say Councillor Rebecca goes and calls on a couple of people, or I do, and I put it into a pathway, that fulfils my obligation there. Thank you.
It does, yeah. Councillor Carl, Councillor McMahon, Councillor Summerfield.
I agree with the comments, but we're talking more than... I agree with the comments, but we're talking more than complaints.
Yeah.
Talk about discussions or deliberations or any council business. I agree with Councillor Nancy. I think there needs to be some... we need to further unpack some of this, and given Councillor Shine's comments about a general understanding of that Public Records Act, there are things that we need to consider, in my view, more holistically, and it's more than a casual conversation and a recording in one's diary. And I'm talking about tone and culture, and I'm sorry, Councillor Shine, it's more than just confidential conversations as well. And it's more than a member of the public feeling uncomfortable. Genuine inquiry, concern, or ideas raised with councillors, my view, wouldn't be fearful of other councillors or staff or officers being aware of that conversation. If it's a genuine conversation issue or idea raised, whether it be in economic development, whether it be environment, whether it be water, it doesn't matter. What I'm talking about is a tone and culture on how councillors, council staff and members of the public, members of the development sector, members of any sector of the community, how we interact and get best outcomes. And look, dare I say, the extreme other end of this is our cousins in Ipswich and Logan had conversations. I'm talking about, from a governance perspective, a healthy interaction that we know that both the community's interests, council, staff and councillors' interests are, one, protected, and two, we're striving for the best interactions and outcomes for all concerned. Now, that's the extreme other end, and we're not, that I use that as an example of how culturally an organisation, a large organisation, over time can think they're doing some things right and they found to be at the other end of the spectrum. That's all, and that's why I raise this, and I agree with some of those informal comments, and we do those. I do some of those things, but there needs to be a standardised approach, and I think that's just good, sound, sensible governance practice.
So
I'd like to see us
right.
defer this,
Right.
unpack it some more, come back and have it included as part of this overarching policy. I agree with your comments.
So that 3.6.2, adding that in there.
No, I think that's
enough?
open for interpretation to the individual.
Righto.
As
Right.
what is a casual meeting, a meeting consistent, not pre-arranged. I think that's, open to some interpretation, and interpretation when there's not a common understanding, even of the Public Records Act, can be misconstrued. So I'd like to see us defer the item and bring it back for, to a further meeting after we've been informed of some of this background, so that we properly understand some of the ramifications, as Councillor Nancy said.
Certainly. I'll just get Mr Wilson to comment. Councillor Nancy flagged that deferment. I've still come to Councillor Tim as well for comment.
Mr Chairman, I'm just getting a sense of where the councillors are feeling about going in relation to this item. 3.6 does sit somewhat uncomfortably with the whole purpose of the policy, so perhaps it's better to just adopt the policy,
Yes.
redact section 3.6, and we can have a further discussion about the content of 3.6 at a later meeting.
Agree.
Yes, I agree with that.
So adopted without 3.6.
Yes.
Yep.
Removing 3.6. Can I, just by way of giving people an opportunity, Councillor Tim, would you like to make a...
Look, I agree with that. I was rather unhappy about, or a bit perplexed. I'm with Councillor Shine. I wasn't under any in the induction training that we were required to have a meeting with any one-on-one constituent at a moment's notice. And I come from an industry where, you know, if you're ever going to have a one-on-one with a student, you don't. And I go into all one-on-ones with people I don't know with this on record, just out of you know, covering your back. But I wasn't under the impression that, you know, sending an email to Nick saying I caught up with this person about the soccer club, whatever, every day when that happens is any different. So I'm sort of feeling a bit uneasy about the whole thing too.
Okay. So, councillors, we do have an option there, as we've said, the recommendation with removal of 3.6, so that council adopt 2.09, acceptable request guidelines for council's policy attachment 1 with removal of clause 3.6.
Be to move.
Councillor Hope, second.
Moved by Councillor Summerfield, seconded by Councillor Carol Taylor. Those in favour? Carried.
Question through you, Chair. Mr CEO, when would that likely to come back to council, or we could unpack that proposal around 3.6 that was removed?
We've got two left there.
The information session on the Public Records Act, for example, that type of thing,
Yeah.
it would be helpful, I think, to new councillors anyway.
Yeah, that is the answer. Exactly. We'll do it the same one that Mr. Wilson was talking about, an information session in relation to our requirements on the Public Records Act.
Okay.
And then we can,
So it will be in the next few months. Which will take place in the next few months, I'd imagine, Councillor Carl. Councillors, we move to item number 7, and number 7, we've actually had a session on this one, which is quote or tender consideration plan for fleet and logistics for service repairs and parts from original equipment manufacturer, OEM. Robin is in the room. If we have any questions, Robin did present this to councillors as an information session. It's a good report, clear in what it's set out to do. Anne-Marie, did you have any comments on that? Councillors, are there any questions in regard to this? Because Robin would certainly be happy to answer those. It's a pretty straightforward tender plan. I guess my only question was that is this an annual requirement for council to consider, given that there could well be adjustments in machinery that's purchased during a year and may well need to add machinery manufacturers to that list, and I wondered whether that's done just operationally or there's a requirement to bring that back to council. Robin.
Mr Chair, councillors, the legislation doesn't prescribe anything that you have to do in that regard. So what the intention with this particular plan is to have it in for 12 months because it's the first time we've done it, to gauge what the real intent, if the real intent is being met or not. During that time, it could be possible that other equipment is purchased that will be under that umbrella. And the intention now is that it will be reviewed in 12 months and come back to council in 12 months.
Thank you. Thank you very much, Robin. Question, Councillor O'Shea?
Happy to move, Chair.
Oh, happy to move. Okay, moved by Councillor O'Shea, seconded by Councillor Melissa Taylor. Those in favour? Motion's carried unanimously with all those that are here. Well done. Councillors, we move to item number 8 on your board books, which is consideration of applications for rate exemption for community organisations, Millmerran Men's Shed and McLagan Windermere Kindergarten Association Incorporated. I believe we do have Shane Morris with us, but I believe we have a declaration to make. Mr Mayor.
Mr Chair, pursuant with section 175E of the Local Government Act 2009, I'd like to inform the meeting that I have a personal interest in this matter, which I recognise may be real or perceived conflict of interest, particulars of which are follows. The nature of the interest is my cousin Michael Antonio is on the executive of Millmerran Men's Shed. I'll be dealing with this declared conflict of interest by leaving the meeting while the matter is being discussed.
Thank you, Mr Mayor. Councillors, just as the Mayor departs the room, Shane Morris is here, the Principal of Rates and Revenue. Shane, would you like to present on this, or Anne-Marie, did you mention something? Happy for Shane. Thank you, Shane, and good morning.
Yeah, thank you, Councillor Jeff. Good morning, councillors. This report deals with 2 applications for rate exemption under council's rate exemption for community organisations policy.
Let the meeting know I'm...
Okay, Councillor Carl. Okay. 1, 2, 3.
So we've had applications received from Millmerran Men's Shed Incorporated and McLagan Windermere Kindergarten Association Incorporated. The applications have been assessed under the policy and it is recommended the applications be approved as the applications meet the intent of the policy given the use of the properties. So I'm happy to take any questions.
Thank you, Shane. Any questions, councillors, in regard to one or either or both of these requests? There is a recommendation before you, councillors, in regard to this. The recommendation is that the applications lodged under Council's rate exemption for community organisations policy 2.02 as detailed in attachment 2 be approved, and that's for Millmerran Men's Shed and McLagan Windermere Kindergarten Association Incorporated. Moved by Councillor O'Hara-Sullivan. Oh, you've got a question? Sorry.
Yeah. Shane, is there a difference between these two in that one's for rates and one's for rent?
Oh, sorry. Yeah, gotcha. Sorry about that.
Okay, so what would happen in relation to both these applications is that you'll notice that the Millmerran men's shed hasn't been rated yet. So what's happened, it's subject to a council lease. And if this application isn't approved, then it will become rateable, so it'll be a rating issue. The other property is currently being rated, so both of them are rates issues. It's just that the Millmerran men's shed currently hasn't been rated because they had to build a shed, and then we've been just waiting for that to complete it and bring the application to council to be considered.
Thank you.
Thank you. Councillor McMahon.
Thank you, Chair. Just regarding the men's shed, just wondering, we have several of them. Do they all receive this same relief? Or are they a case by case, or?
If we look, to my knowledge, is that men's sheds would be exempt under this policy. So, for example, if we became aware of a situation such as this, whether normally they would be council lease properties, but they could also potentially be owned by, the men's shed group. So what would happen is that if they hadn't applied for a rate exemption and we were aware of that, then we would recommend that they do apply. So we would be seeking consistency for the likes of men's sheds.
And women's sheds?
All women's sheds, if that indeed happened, yes.
Thanks, Shane. Does that answer your question?
Yeah, so they're only $132 a year, am I reading that right?
That is right, but at the moment, that's what they pay in rent, which is all part of an agreement. However, it's currently not showing any rates there because being council-owned land, up until now it's been non-rateable, but if this isn't approved, it will become rateable.
Councillors, I just make a note that we are only dealing with the Millmerran shed one at the moment. I made comment before, but the Mayor will be able to come back in for the second one.
Righto, yeah, okay, yeah.
So, Councillor Taylor?
I'm happy with it, thank you.
Councillor Shine?
It relates to the second one?
Second one, okay. We'll deal with the first one first, if you don't mind. So, someone like to move? Councillor McMahon? Moved by Councillor McMahon. This is for Millmerran's men's shed. Seconded by Councillor Carol Taylor. Those in favour? Motion's carried unanimously. Thank you, Nick. We'll bring the Mayor back in. And then, Shane, if you don't mind, we'll deal with the second one, which is the Maclagan Windermere Kindergarten Association. Mayor's not... Here he comes. It's okay. Thank you, Mr. Mayor. We're just dealing with the second of those applications now. And Councillor Cole, we're up to the second of the applications. This is the Maclagan Windermere Kindergarten Association, which uses an early childhood kindergarten, offering a program for children aged from 2.5 years to prep for Maclagan, Quinlow, Culpi, Kuya, Hayden and surrounding communities. Thank you, Shane.
Okay, councillors, with this one is that we're of the view that this one does meet the criteria. Just one unusual probably thing with this particular application is that the property is actually in private ownership, but that in itself doesn't sort of prevent council from considering such a matter because what happens is that the property is subject to a private lease. It is used as a kindergarten. Kindergartens run by not-for-profit organisations, I would suggest would be typically exempt under this policy. So the mere fact that it's owned by in private ownership. The other thing too, that what's brought this to council is that the property ownership changed due to the passing of the owner, and that property has now passed to his within his family. But they are seeking just to continue the lease arrangements under the same arrangement. So probably, if you like, what's happened is because it changed ownership, it's gone from being non-rateable to rateable. So we've now just putting this matter back to council to see if council is comfortable to consider to continue the non-rateable status of this property.
Thank you, Shane. Councillor Carroll?
Chair, I'm happy to move this, and the reason that in these smaller communities, it wouldn't be possible if they had to run on commercial grounds, and I think that it's most important that our young people out in these regional and rural areas have the same access to preschool and to kindergarten and that they do in the bigger communities. So, and they wouldn't be able to do that without council's help. I'm happy to move this.
You're happy to move that, Councillor Carroll, seconded by Councillor Megan O'Hara-Sullivan. Those in favour?
I just wanted to ask a question.
Question, sorry, Councillor Shine, you did have a question on this one.
Yeah,
I've got a mover and a seconder, that's fine.
I think, Shane, you addressed the issue of the private ownership, and I take it, one assumes that the lease probably makes allowance for the fact that rates are not, the obligation to pay rates may well have been on the kindergarten as opposed to pursuant to that lease. And, that's correct. I'm just wondering what happens if the kindergarten moves, is no longer present there. Will the council sort of have notice of that, or because the exemption would still apply, wouldn't it, until it's changed?
Okay, so just to answer that, Councillor Shine, is that if we were informed that the kindergarten had moved from that property, then the property would become rateable again automatically. If they didn't inform us and we're unaware, there's obviously a risk there. So we are looking, we do need to review all these exemptions from time to time. With many of those reviews is that through local knowledge and so forth, we often know that those uses are continuing. But if we had a doubt, we would then sort of make relevant inquiry with the owner.
Thank you. So we have a mover and a seconder. Those in favour? Motion's carried unanimously. Item number 9, councillors, is another rate exemption. This one, however, has a different recommendation. This is consideration of application for rate exemption for community organisation North Toowoomba Bowls Club Incorporated. Again, I'll hand over to you, Shane.
Okay, councillors, so this application has been assessed under the policy, but on this particular matter is that it's recommended that it not be approved as it does not meet the intent of the policy given the use of gaming machines and regular trade with the liquor licence. So basically, as a general principle is that organisations, community organisations that do trade routinely, regularly with a liquor licence and have gaming machines are not granted exemption under this policy. So hence the recommendation simply follows the fact that it is used, has uses of gaming machines and regular trade with liquor licence.
Thank you, Shane. Question from Councillor O'Hara-Sullivan.
Jane, are these organisations advised of that in advance, like rather than going through the process? It's pretty black and white, isn't it?
Yes, so thanks, councillor. So with applications, when we get involved is we will send the applicant a copy of the policy, and the copy of the policy details council's requirements. Now in this particular case is that even upon a self-assessment, it would be reasonable that the club would have formed the opinion that this wouldn't be approved by council. However, in saying that though, is that I can't prevent them from applying for it and I can't stop it from being brought to council for consideration.
That answer your question? Councillor Shine?
So just a further clarification on that. It's a set policy of council that if you do have gaming machines or a liquor licence, you're not eligible for consideration for exemption. Is that?
That's the general intent of the policy. The policy clearly states that out. There are some limited exceptions, not in relation to poker machines, gaming machines, but in relation to liquor licences, we do actually have a small number of clubs, excuse me, where they may just trade, 2 afternoons a week with a liquor licence or something like that. So probably, if you like, is that a liquor licence issue isn't necessarily absolutely black and white, but certainly is that if they're trading routinely, particularly if it's most days of the week, then we would think that wouldn't comply with the policy.
I suppose I'm not alone here, but anyone associated with or knows anything about the North Bowls Club would be sympathetic to their request because of the good things that they do. They house, for example, the Harlexton RSL. That's where they meet and practice and all of those sorts of things, and they perform very worthwhile local community activities. But and I suppose the correct thing to do would be to seek at some stage a review of the policy, as opposed to as Councillor Hara Sullivan said, if it is black and white, and I think we have no alternative other than to agree with the recommendation, which you put it up for that reason, I would have thought. But I would like some review of that. Perhaps might be relevant to examine how many poker machines there are. My only experience with a club running poker machines was some 20 odd years ago, and it wasn't a very good one in terms of the financial outcome of that. Just because you've got poker machines doesn't mean you're running, overflowing with money at all. So it might be, I think it's probably time that we should look at that, especially in small country areas. They might well have a couple of poker machines, but why should they be, there's reasons why they should not be eligible for application, I think.
And I would just thank Councillor Shine for your comments. And I would sort of say that overall the policy has served the council well over the last 10 or so years. However, certainly, so given your comments, I would be happy to have the matter come back as in a review of the policy in due course, and we would be happy to organise that for the near future.
Thank you.
Certainly, and policies are reviewable at any stage, but this would be, if it's 10 years, it's probably high time that we have a re-look at it anyway, and there might be some other things in there that might need strengthening or otherwise based on the last 10 years, perhaps. Any other questions, Councillor Carroll?
Questions, Mr Chair, but I'd like to pick up on Councillor Shine's comments about North Toowoomba. They do an amazing job up there with the RSL, as well as the Harlexton RSL brass band. And just the comment that all of these clubs, because of COVID, would be feeling the pinch whether or not they had poker machines. So I guess that, our hands are tied here, but it is a club that's very active, and they do an enormous amount of good in our community.
Thank you. It's probably not dissimilar, I guess, councillors, to our community grant process as well, and the policies that are around there for not-for-profits, for licensed venues, for others. So it's probably a similar scenario, I would suggest, in some of these cases. But we have what we have before us at the moment, and because it is in the policy doesn't mean that it cannot be considered. I'll put that out there as well. However, the recommendation, given the policy, is that it's not accepted on this occasion. Do I have a mover? Moved by Councillor Summerfield that the application lodged under Council's rate exemption for community organisation policy 2.02 as detailed in attachment 2 not be approved. Moved by Councillor Summerfield. Seconded by Councillor Antonio, the Mayor. Those in favour? Those against? Motion's carried. Thanks, Shane. We move, you're back on again, Shane.
Yes, I am.
It's good to see you here. Item 10, councillors, is the amendment to Council's 2020-2021 Register of Fees for a particular interest. And Shane, you might explain that one to councillors. Thanks.
Okay, councillors, this report deals with the ongoing waiver of the card surcharge. Just for councillors' benefit is that there is a card surcharge has been applied over the last 2 years at 0.33%. It's just to assist council recoup some of the banking costs in processing card transactions. What happened is that as a result of the COVID experience is that back in April, council decided to forego the surcharge for a period of time, so to say, and it was due to come back to life on the 1st of July. With this report, we probably provide a couple of options for consideration of council. Is that one is that the surcharge be deferred and just be reintroduced at the next opportunity, which would be on the 1st of August. we could defer it for 3 months and reintroduce it on the 1st of October. Another option would be to defer the reintroduction of the charge until further notice. So one of the drivers to the deferral has been to continue to encourage contactless and cashless transactions, particularly during this COVID-19 pandemic. So the recommendation ends up sort of being a deferral of this charge until further notice, given, I suppose, the whole COVID experience is something that continues to go on and on. And I suppose the thing is that certainly the council, like many other organisations, has been encouraging a cashless society during this particular time. And we're subject to that when we do our grocery shopping and all the rest that goes with it. So I've made the report makes the recommendation to just continue to defer the charge until further notice. I do probably suggest that if we did that, so it doesn't get forgotten about, that we would probably bring it back to council as part of the consideration of the annual fees and charges. So that'll be around, say, next March, something like that. Sort of so, and by that stage, one would hope that the whole COVID situation would be far better understood than what it actually is now. And council might be in a much better position to consider whether it wants to bring the charge back in at a certain point or indeed not bring the charge back in. So, anyway.
So just, Shane, just on that recommendation, that covers off on what you're saying, because it will come back then for fees and charges for 2021-22, given that we say amend the current register, deferring the introduction for this financial year. Do you need any strength in there to suggest that it needs to be reconsidered, or are you happy just with that wording in there? That gives you enough guidance and direction?
I think, Councillor Jeff, that it does. Like, for example, is that to bring it back for further consideration as part of the fees and charges would be a reasonable thing to do. And indeed, at that stage, council can decide whether it wants to bring it back in or whether it doesn't. So,
yeah, terrific. Okay, Councillor McMahon and Councillor Carl.
Thank you, Chair. Shane, I'm just wondering, we charge that because the bank charges us.
that's correct.
The bank's deferred this charge for FPOS facilities?
No, so the bank continues to charge council for the transactions. So bear in mind, I'll just explain that this applies to card transactions. So, but I'll just explain a little bit further, just for the benefit of the councillors, is that just like whether you're using council or whether you're going to do your groceries, if you pay wave, even if it's with a debit card, that automatically becomes a credit card transaction. It's processed through the card system. So therefore, if the bank charges a surcharge, or actually applies an extra fee for that, then that must be absorbed by that particular organisation. If you put your card in, put your PIN number in, and it's coming out of a debit type of account, we only receive a very moderate fee, like 5 cents or 10 cents a transaction. So, but what's happened is that as we go cashless, is that we are also encouraging it would be as much PayWave driven as possible. Now, I know that PayWave requires customers to put in a PIN number up to above a certain limit. But at least what it does, though, it negates as much as possible the need to even touch an FPOS machine and put in key numbers in. So, but you are right, is that we do continue to get charged the fee. Local government is on a fairly low fee structure in comparison to most commercial entities. But nonetheless, though, it is a cost to council, which probably runs at around $100,000 a year, just in round numbers. So that's what the surcharge seeks to do, is just recoup those card processing costs.
Could I follow up, Councillor McMahon?
33%, do we make a profit?
We're not allowed to make a profit. So what we must do is that we set the fee at the highest charge that we're applied, because it depends on whether it's a MasterCard, whether it's a Visa card, and various other things. That it's quite a complicated structure. So we are not allowed by law to recoup any more than the actual cost of the transaction.
Thanks, Shane.
I think Councillor Vonhoff, you've got a question?
It was a question / a comment, thank you, Mr. Chair, that this prompts me to consider whether we should raised this in our LGAQ, as an LGAQ submission, that local government make a submission to the banks that surcharge is waived. It's worth asking, Councillor
Oh, too right.
McDonald.
I'm all for it. Great idea.
Yeah, and I would, sorry, Councillor, and I would agree with those comments, because one of the interesting things that's happened during the last 6 months or so is that if you made a BPay transaction using a credit card, council incurred a fee, it no longer incurs a fee, well, apart from a flat base charge. So it may well be that the banking industry may be open to such a consideration.
Particularly with COVID and...
Yeah, exactly. Councillor Carl.
Happy to move the recommendation, Mr Chair, with the addition that Shane has suggested that it be reviewed at the annual fees and charges next March, or annual fees and charges review.
Just a comment while Wendy's doing that, if you're happy with that, Shane, and maybe a question, not sure which way. We're talking about a revenue loss here, if you like, of $104,000, but would it be correct to assume that there could be also some savings in the organisation as a result of the cashless transactions as opposed to cash or cheque or whatever it may be? There would be a saving that would balance this cost as well, or revenue reduction?
There possibly is some minor probably offset. What happens is that our banking will still get collected sort of by a security company because it involves potentially some cash but also cheques. So we'll probably still receive the same banking, cash collection or banking costs each day. But I suppose it certainly does probably, like dealing with less cash means that transactions are often quicker. Certainly balancing routines at the end of the day are quicker. You probably have less issues with probably having cash errors at the end of the day. So it probably would be unlikely that the savings would be totally offset the cost, but there would be some influence.
Sure, that's just a comment there. There's Wendy's just putting the additional item 2 down there, Councillor Carl, if you want to just have a check of that.
Just put in the 21-22, put the year in.
Okay, could we add, Wendy, in there that instead of annual, just say the 21-22 register of fees? That cover off, Councillor Carl? So just to read that, it's the Council's position in relation to recovering the card surcharge of 0.33% of all card transactions be reviewed when considering the 2021-22 register of fees and charges. You happy to move that, Councillor Carl? Kerry, Councillor Shine, did you have a question?
Just a comment in relation to this, if I could. This represents another measure by the council to relieve the impact of the COVID-19 influences in our community. On top of the $125 rebate per household, the procurement benefits given to business, and later on today we'll consider other exemptions from duties that apply to sporting clubs, etc. And I think it's important for the public to realise that the council is indeed paying its part in helping our community face this challenge of COVID-19 in a very material and worthwhile sense.
Thanks, Councillor Shine. Are you seconding that
Happy to
motion?
second.
Moved by Councillor Carl, seconded by Councillor Shine. Those in favour? Carried unanimously. Is that it for you, Shane? It is. Thank you. Good on you. Item number 10, councillors, is nice segue too, Councillor Shine. Great segue. Consideration of proposed amendments to Council's 2020-2021 Register of Fees and Charges. Michael Condren, if you're available. Hang on, this is a consideration of park bookings. This is number 11.
So it's in the
Same vein.
Yeah,
Same vein, different train.
Thank you, Chair and Councillors. Council, you'll be aware that the COVID-19 pandemic has significantly impacted the scheduling of training and games associated with our normal winter sporting season that normally runs from March through till September. So quite a number of clubs have identified very significant reductions in participation rates and lower income as a result of the pandemic. Councils will be aware through our fees and charges, we normally, apart from our junior sporting clubs, we charge for seasonal hire both for our winter sporting users and our summer sporting users. But because of the impacts of COVID, I guess the recommendation, the report identifies the council a request to consider potential waiving or reduction of sporting fees for the winter season to cater for the impacts of the pandemic. And happy to take any questions.
Thanks, thanks, Michael. Any questions, comments? Question for Councillor O'Shea.
Yeah, thanks, Chair. Look, fully support. I think it's a great step for all the reasons you've outlined, Mr. Conran. The only question I'd have is that just with the pandemic and situation that we've had, we've still obviously had a strong uptake in sporting organisations group wanting to utilise our fields.
Absolutely, and I think we've touched on it in some previous discussions. We will face a situation at the end of this season where the winter sporting clubs, or some of them at least, will be seeking to possibly extend their season beyond the normal termination date of the 30th of September. That obviously represents some challenges for the sporting clubs in the summer season. So we'll be working very closely with the associations and the groupings to try to accommodate the requirements of the extended season for winter sporting users. But it will be by agreement, and the priority summer users will have first call on the sporting grounds for the summer season. We're looking at opportunities, for example, with soccer who wish to extend their season. We have some facilities that are not used in the summer season, like Oakey, and we'll be encouraging those clubs to consider possibly utilising those types of facilities so that it can extend their season without impact on the summer sporting codes.
Okay.
It's just a final
follow-up.
Mr. Chair, yes, and so as I said, yeah, I'm fully supportive. I think it's a great outcome and echoes the sentiments of Councillor Shine before and how we're able to assist the community during this period. And just finally, just one last comment, a big thanks to Michael Conran and the staff out there. I can assure you I've been inundated with calls from sporting clubs wanting to get back involved and how they can go about it. So, and the staff obviously had to do a tough job in an uncertain time of knowing when and what capacity. So I think credit to the staff for looking after it. And there's probably a few other questions or comments, but I'm happy to move, Mr. Chair.
Okay. Any other questions or comments, councillors, in regard to this?
Seconded.
Councillor McMahon? You're happy to second it? Councillor O'Shea moves, Councillor McMahon second, as per the recommendation, which was that Council waive park hire fees for sporting clubs for the 2020 winter sporting season concluding 30 September 2020 in recognition of the adverse impact of COVID-19 on field use for sporting clubs. Those in favour? Carried unanimously. Thanks, Michael. Thank you, Anne-Marie. Can we move now to adjourn the meeting? We don't have to move, we just adjourn. We'll adjourn the meeting. We do need a mover. Moved by Councillor O'Shea, seconded by Councillor Von Hoff. Those in favour? Carried.
Please, can I recognise the staff who are here and the work that's been done around this? Also, Shane and Ali from TSBE, good to have you here. Can I also recognise the traditional owners of the land on which we meet today and pay my respects to their elders past, present and emerging. First item we do today will be the funding agreement. That's item 3 on the economic development list. The funding agreement with Toowoomba and Surat Basin Enterprise. I'll introduce Seamus, but before I do, ladies and gentlemen, for those of you who know Seamus on Facebook, it was his birthday yesterday. Well done, Seamus. Right to go.
Mayor? Mr Mayor, I'd like to declare an interest.
Sorry?
I'd like to declare a conflict of interest.
You'll declare a conflict?
So I'm just read it out. So pursuant to Section 175E of the Local Government Act 2009, I would like to inform the meeting that I have a personal interest in this matter, which I recognise may be a real or perceived conflict of interest, the particulars of which are as follows. The nature of the interest is I have a personal friendship with the Chief Executive Officer of Toowoomba and Surat Basin Enterprises. I will be dealing with this declared conflict of interest by leaving the meeting while this matter is discussed and voted on.
Okay.
Mayor, I too have a declaration to make, if I could. Pursuant to Section 175E of the Local Government Act 2009, I'd like to inform the meeting of a personal interest in this matter. Hang on, have you got this up there, Wendy, by any chance? This is not quite right, the one I've got here. That's the one, yeah. Pursuant to Section 175E of the Local Government Act 2009, I would like to inform the meeting that I have a personal interest in the matter which I recognise may be a real or perceived conflict of interest, the particulars of which are as follows. The nature of the interest is the family business Cracker Print and Paper, Pty Ltd, is a foundation member of the Toowoomba and Surat Basin Enterprise, Pty Ltd. I have determined that this personal interest is not of sufficient significance that it will lead me to making a decision on this matter that is contrary to the public interest. I'll best perform my responsibility of serving the overall public interest of the whole of the council area by participating in the decision and voting on this matter. However, I acknowledge that the remaining councillors must now determine, pursuant to Sections 175E4 of the Local Government Act 2009, A, whether I have a real conflict of interest in the matter or a perceived conflict of interest in this matter, and B, if so, whether I must leave the meeting while the matter is discussed or voted on, or B2, I may participate in the meeting in relation to the matter, including by voting on the matter. If there's no questions.
Are there any questions for Councillor McDonald before he leaves the room? Councillor Carl?
Yes, through you, Chair. Councillor Jeff, has your business or entity ever provided services or goods to TSB at any stage in the past?
No, I don't have that close a contact to family business operations on a daily basis, Councillor Carl. Nothing that springs to my mind of any significance or at all comes to my mind. As I say, I have a separation to our business in regard to a general manager that operates the business, and I keep it arm's length from day-to-day operations. So knowing who our clients may be at any given time is a difficult thing for me to do.
Yeah, I just ask in the context that, you know, you say that you're a foundation member, and usually in memberships with any or these type of entities, members often conduct business amongst their membership, and that's the reason why I'm asking.
That's fine. I think foundation member may well be just we joined when it was founded. I think that's where that comes from. There's no special privileges, as I understand it, as being a foundation member. Yeah, and certainly from a business perspective, our accounts would suggest on a helicopter view that there's been nothing of any significant nature being provided or produced for the organisation.
Any other questions around the room? Councillor Melissa.
Thank you, Mr Mayor. Through you, it's actually not a question. I actually inadvertently didn't even think. We are foundation members, Taylor's Removals as well, so I must declare that interest as well. And to answer the same question that you will have for me, Councillor Carl, is that on occasion we have used the Tisby boardroom because we don't have a boardroom facility occasionally. And we have done 2 or 3 moves over the last however many years, office material. So nothing of any significance at all.
Okay.
Do you want me to read that, or can I?
You wish, any questions for Councillor Melissa Taylor? Okay, thanks, Councillor Taylor. You may leave the room and we'll have a discussion here and I'll let you know. We'll begin with Councillor Taylor. Councillor Melissa Taylor, anyone want to make a comment, or do you want to just simply put it to the vote?
Could I ask the CEO for some advice on this? He's probably thinking, but if I could, please, because, yeah, I just want to have clarity of mind, please.
Councillors, you just have to apply your minds as to whether there is any potential advantage or disadvantage through that relationship that they've just declared to each of those individual councils in their own circumstances. And the matter that's being considered today is, and the relationship as to the matter that's actually being considered before council. So the matter before council today is the funding for the purposes of council providing that to TSBE. So that's the matter that's being considered. So you've got to consider in your minds, is there a nexus between the funding that's provided to the TSBE, the council's position on that vote, and is there any potential for their vote to be influenced by the relationship that they may have or have declared that they have with the with TSBE in each of their separate cases?
So if I could just add to that, if you were a member, you know how we've gone through this in the past, where if you're a member of a club, say for example a turf club, but you're not on the executive, you're entitled to stay in the room. Would this be considered the same? The foundation membership or any of those memberships, would that be considered along the same lines so long as they were not on any executive? Is that the same, or is it a...
Good question. Memberships on sporting bodies and committees like that, certainly there's not an issue with that. In relation to this one, I think it's a little bit more complex than just being a member, per se. I suppose I think you've just got to go to the core issue is about whether there is an advantage or disadvantage for that particular councillor that could or potentially be perceived to influence their vote in relation to it.
Thank you.
Okay. Councillor Taylor, then Councillor Carl.
Thank you, Mr Mayor. Just further to that, it's a council organisation with members, paid up membership. How many members, and it might have a correlation, I don't know, because with like the Turf Club, there's hundreds of members, and unless you're on the board, but this is a member-driven board. Would it be regarded as a member-driven board, or is it? I think that's probably part of the issue, isn't it?
Yes, there are a number of members, and I have that figure here. If I can find it, 450 members.
Oh well, that's
Tisby.
Quite a lot of members, and. Yeah, I don't know. I think with that many members, just membership, I'm not sure. I personally don't believe that there's any advantage to be gained, but I might need to think about that for a minute.
Okay, Councillor Carl, you had your hand up.
Yeah, thank you, Mr Chair. I'm of a differing view. I think that the quantum of membership warrants the potential for a conflict. In other words, how much people pay to be members, and the the framework that surrounds TSBE and why people are members, and we are talking about a funding agreement, and that could be construed, it's not by the people in this room, it could be construed by any member of the public as a perception of conflict even, that councillors, of which some are members of TSBE, are voting to grant for the next 3 years funding, of which there is a potential for gain or loss, irrespective. Councillor Melissa's already told us that she's received benefit by using the boardroom, albeit a small gain, and has done some removal jobs of office furniture, which is she's received benefit to her business from being a member. And she's, if it was me, I would remove myself and not be involved in voting on any funding agreements or such matters. And the same, in my view, exists for Councillor McDonald, in that whether he has or hasn't, there is the potential over and above any other councillor, because he is a member, to receive benefit, and over and above other members of the community who are not members of TSBE. So I think it's probably goes some way to an MPI, not just a personal interest or a conflict. That's my view.
Thanks, Mr Chair. Through you to the CEO, what's precedent here? So in past conversations and past decisions with Toowoomba Regional Council and Councillor McDonald, what was the decision, and was there an issue with whatever that previous decision was?
I've just been advised that a search on those previous minutes didn't reveal that there were any conflicts revealed, declared at previous meetings in relation to this matter. So I don't think it's been raised before, but we're in a heightened, I suppose, position at the moment where it's certainly at the front of mind of all councillors to be to make a declaration, and in this case, to be sure to actually give it to the council to make a decision on that. But from previous, it doesn't look like there's been a previous declaration of anything.
It's no help. Thank you.
Any other comments around the room? We are reaching a stage of, and if I can just let loose on this one, it's very difficult to manage a meeting of this nature when you've got this sort of thing happening, and the potential there is for, for reporting, all the rest of it. It's very difficult. At the same time, we've got three very capable people in this room who've left the room because of personal interest who could contribute significantly to the discussion. So I guess I'll hand it over to you people. It's in your hands to work out whether you want, whether you allow Councillor Taylor and Councillor McDonald back, and we'll do them individually if that suits you. And the normal thing is just a show of hands.
Individually.
Individually.
Mr Mayor.
Yes, Councillor.
Just to throw something else into the mix, I'm personally of the view that Councillor Megan left the room unnecessarily.
I agree.
Well,
that's her decision.
That's her decision, and she chose in this environment to get out of the room.
Yeah, it also
And
speaks.
that's something I think we need to address. We need someone to come here and define some of these issues. We haven't been able to get it. I know people who have written off to the Integrity Commission and asked an opinion. They don't get an opinion. They do not get an opinion. And you understand that very clearly. And I don't think that's appropriate. I really don't, because this is affecting the governance of this organisation. It's affecting people's confidence, and it's affecting the culture of this organisation. So I'd suggest, Mr CEO, somewhere in the future we try to get something definitive. We've got possibly the Premier and the local government minister coming next Wednesday, and it might be a good topic for discussion, because this boardroom is not the way I would see a good functional boardroom going in view of all these circumstances. It's in your hands.
So So just, if I could just follow up on that, please, Mayor. What Councillor Carl's saying is that we have one councillor who has left the room who did not need to leave the room, and do we as a council decide whether it is appropriate for her to leave the room, or is it her decision entirely?
Well, I think she's made a choice, and she's decided, she made it very, very clear that she's leaving the room, and she has her own reasons for doing that, Councillor Summerfield. Councillor Vonhoff?
Thanks, Mr Chair. Then, I mean, given this bind that you've just articulated, and the delays that we experience, is it the independent assessor CEO who we request guidance from, or is it the Triple C?
Well,
what's the body?
I think everybody's exceptionally cautious about giving guidance, and if I was the CEO, I would refer it immediately to a higher authority, like the Integrity Commissioner or somebody like that. And this is where we are.
So then,
and, you know, we've been talking for 10 minutes about just matters that should have been like that. Councillor.
Sorry. Then, so then, supplementary question: are we even in a position where we feel that we have advice to act on here, or do we need to get information from the Integrity Commission or the Independent Assessor before we get into the motion that's up for consideration?
Absolutely.
Mr Mayor, can I just say, nothing really has changed. It has always been the responsibility of the councillor to decide. Nothing has really changed. It's always been the responsibility of the individual councillor to decide should they be in the room or should they be out of the room. There's guidance, and you're right, they won't give you a black and white answer, the Integrity Commissioner or the other person we had come talk to us. But at the end of the day, I mean, you know, it does come down to the fact that that councillors have to decide themselves. And I've been in a situation where I was taking myself out of the room, and I actually got scolded for it, because I was told and it was the assessor that told me that I should not have been leaving the room in the first place.
Yep.
So at the end of the day, you know, I mean, I think it's up to the individual councillor to get their own advice, and it's always, ever since I got on local government in 2000, it has always been the responsibility of the individual councillor to make that decision.
We understand that. Councillor Vonhoff, you had your hand up again.
Yes, thank you, Mr Chair. So I would suggest that, and it's a terrible waste of people's time who are here today, and our time as a council as well, that we need to seek information about this issue from the Integrity Commissioner, about Councillor O'Hara-Sullivan, Councillor McDonald and Councillor Taylor, because this is an issue that we're going to come up against again and again, and I would feel much more reassured about the position that we're taking, having received some guidance from the Integrity Commissioner.
Councillor Carl?
We've got a quorum though.
Whilst I appreciate those comments, the advice, my experience you get back is that the council is charged with the responsibility of determining, because both councillors have asked, this council is charged with the responsibility of determining whether those councillors have a conflict or not. I've openly and transparently shared my view of the potential conflict and the potential advantage that both of the councillors McDonald and Melissa Taylor could find themselves in receiving benefits as a member, both directly or indirectly as part of this organisation, and why I think they're conflicted in voting on financial matters that could see them receive directly or indirectly benefits over the next 3 years as members of TSBE. I think the advice will come back, they'll point it out to you clearly in the legislation now, that under the guidelines of what's just happened, it's for the councillors to decide right around this room now.
Councillor Summerfield, and I'm about to close the debate.
Yeah, thank you, Mr Mayor. Look, this is taking up a lot of time. I think Councillor Carl is basically putting forward that they should stay out of the room. I think we do need to vote on that, and could I suggest that we actually try and get information between now and the ordinary meeting next week, so that we have clarity for next week's meeting and that we get on with it, please?
Yes, I agree.
I'd love someone to quantify for me what benefit it would be to either of them. I would love to know that, because I really can't see it. I think that people need, you need organisations to represent you, and we've got one here that is. And I'm disappointed I'm disappointed in advance that I know that we won't have two councillors in the room, or three, in fact. This is about the broader aspect. It's not about $50 here or there and the use of a boardroom or something of that nature.
But, Mr Mayor, if I could just make a comment, friendship is an interesting one, because I count myself as having lots and lots of friends, and if I got myself out of the room for every thing that was being voted on because I was friendly with someone, I would, but that is up to Councillor O'Hara-Sullivan. I'm not making comment on her decision to do it, but I would not be doing it.
Okay, well, I think we've had enough discussion around that, and there's been a fair few opinions put around the room. In respect to Councillor Melissa Taylor, who wants to have her in the room for the discussion? 1, 2, 3, 4, 5. Who wants her out of the room for the discussion? 1, 2, 3. Melissa Taylor may come back when we'll decide the next one. Councillor McDonald?
Just need reasons.
So, reasons? Because, well, as far as I'm concerned, I can't see that she's got a sufficient conflict.
Gain or loss?
To gain or lose anything.
Yeah.
So do you want me to get her?
Yeah. Do we bring Melissa back in now for the next?
Who moved that?
They separate.
Who moved that?
I don't think that's point of order, Mr Chair. I wouldn't imagine that would be appropriate, given the fact they left the room for the same reason.
Righto. Sorry, Councillor Summerfield. Councillor Carl has questioned Melissa coming back in the room, so we'll have to keep her. Good. Okay. So we'll move then to Councillor McDonald.
Who moved the first motion? Sorry.
Who moved the first motion?
It's got to stay out then, if we've done...
We're still on Melissa, I think.
Did you move the first?
So,
You are.
Mr Mayor, a point of order, I don't believe we had a mover and a seconder.
You just asked the question.
We
those
just
who-
asked
A mover and a seconder?
a show of hands, I think.
Yeah.
Well, do you want to formally move that?
Formalise it.
Someone to formally move that? I'm sure I did. I'm sure I picked someone out, but this is a bit of an emotive exercise for me. Councillor Shine has moved. Seconder, please. Councillor Von Hoff. Those in favour of Councillor Melissa Taylor coming back in the room? Right. Now, can you determine for me whether Councillor Taylor should come in now
Well, I suggest she can.
and be part of the...
Yes, she can.
We have just voted, Mr Mayor. I suggest that
Before, I'd like to call a division of the vote on that one as well, please.
divisions aren't done in committee, I'm informed by the CEO.
Okay. There has to be some avenue of how vote was recorded by Mr CEO, and I'm not sure how we do that at next week's meeting, because do we go through this process entirely, in its entirety again?
Okay. Move then to whether Councillor McDonald should be in the room or not.
I just want some clarity, Mr Chair.
Some clarity. I'll ask the CEO. Thanks, Councillor Carl.
We don't usually record that, but if it will add to the, I suppose, the clarity of the decision, we can record that in there for the purposes of this debate. We need a division.
Someone want to move that it would be appropriate that we move that the votes be recorded so that there's a formal process here?
If you can just ask for the division who voted for and against, we'll record them.
In this circumstance now?
Yep.
But we just said before we didn't have divisions in committee meetings.
No, we don't.
No, I'll just keep a record of it in the.
Let's keep a record of it.
Keep a record. Right. We move then to Councillor McDonald, whether he should be in the room or not. Do we have a mover? Councillor Shine and Councillor O'Shea. That he be in the room. Those in favour of Councillor McDonald returning to the room?
The reasons?
And the reasons being? Councillor Shine?
I don't see there's any sufficient reason to prevent him from participating in this discussion.
No loss or gain.
No loss or gain, yeah.
Those that were against on that one?
Those that were against it want their names recorded, please. Councillor Summerfield and Councillor Carl. Okay, Councillor McDonald may return to the room. James, you're on.
Thank you, Chair, and good morning, councillors. The report before you today is to consider a request from TSBE for a continuance of the funding that council provides to them for an additional term of 3 years under the existing conditions. So, as council would be aware, TSBE is a controlled entity of council. It was established back in 2011. Council provides an annual contribution of funding to TSBE to deliver economic development activities on our behalf, and they are mandated through a funding deed and some key performance indicators associated with that funding deed. And they specify what council's expectations are on TSBE for the provision of that funding. So the request is for another 3-year term. That would take us through to 2023. So the funding deed that's in place at the moment finishes at the end of this calendar year. So I guess it goes through to the end of the 2023 calendar year. I would suggest that the funding deed that has been developed in association with the report has not as yet been considered by our legal section. I'd note that the previous funding deeds had been considered by our legal section, but we propose that if council is positive about moving forward and confirming the extension of the funding, that the CEO has the capacity to negotiate the final version of that funding deed under delegation. I would be happy to answer any other questions that councillors may have.
Are there any questions? Councillor Von Hoff?
Thanks, Mr. Chair. Through you, thanks, Seamus. The existing funding agreement, how many years is it?
Yes, so all of the previous funding deeds have been for 3 years. So this would be the 4th funding deed between council and TSBE. So as I noted in the report, that would remain within the term of this current council, which I think has been raised as a consideration for previous councils in terms of, I guess, imposing that financial obligation on a future council.
Yes. Councillor Summerfield and then Councillor Shine.
Yeah, thank you, Mr. Mayor. Look, I'm very supportive of this, but I just wondered whether recommendation 1, and I seek your guidance, Mr. CEO, whether the end of adjustment each following year, should that include for the life of the deed?
I think that's actually what the recommendation says. It says for each following year.
Oh, yeah, for 3 years, sorry.
Yeah, so it's actually already entire.
3 years anyway.
Yeah.
Thank you, sorry.
Mr Mayor, can I just make a
Oh,
comment?
sorry. Sorry, I had Councillor Shine.
Okay.
Then I'll go to you.
Okay.
Sorry, Councillor Shine.
Wouldn't matter. You mentioned that there will be consideration being given to the drafting of the relevant deed. In so doing, could you have consideration be given to clause 17, which is the goods and suppliers policy, to see whether it can be brought in line with council's current procurement policy in terms of local businesses, etc. It's would be very appropriate, I would have thought, for TISB being its main raison d'etre is to support local business, to require it to look after local business in terms of its own procurements as well. Thank you.
Noted, thank you.
Could I comment on that, please?
Just a brief comment, then we go to Councillor Taylor.
My concern with that is Toowoomba and Surat Basin Enterprise isn't just for the Toowoomba region, it goes all the way out to Roma. So we need to be careful about local, because it could be local in Roma or Dalby or wherever.
Yeah, no, that's fair enough.
Councillor Taylor.
Thank you, Mr Mayor. Look, I'm just wondering if that this is a draft agreement, and I'm wondering if we, the council, because we've got 4 new councillors, are able to have an information session on that prior to this being signed off on. I mean, not for any other reason, I support it as well, but I just think it would be, you know, some of us were there at the formation, and I just think it'd be really good. It's a draft for a lot of reasons, with the legal and other things, but it would be I think it'd be really advantageous for us to have an information session and just go over it with councillors.
Just go over the funding draft.
Yes, in case there
agreement.
were small, minor changes.
Understanding.
Yes.
This would, the motion at the moment would be handing it over to the CEO to...
yes, and this...
but just to give an understanding, I don't have a problem with that. I don't think anyone else would have a... You know, I think the agreement and the partnership we have with TISB has been a tremendous benefit to this community. A tremendous benefit to the broader community. Western Downs, Roma, a whole lot of places. Tremendous benefit.
And Mr Mayor, just to follow that up, but the way it's written with the CEO, if there were minor changes, then council could put those forward through our CEO, if there were just some minor changes.
Okay. Right. Councillor Melissa Taylor.
Thank you, through you, Chair. Thank you for the recommendation, Councillor Taylor, but I do not need an information session. I'm fully aware of what this agreement says, and fully aware of what TISB does add to not just Toowoomba Regional Council, but as far as Roma as well, and Queensland and Australia basically. So I don't need a information session to go forward.
Councillor McMahon.
Thank you, Chair. May I agree with Councillor Melissa Taylor that I feel adequately equipped to make a decision on this today. Just a question, if I could, the 24,000 increase from 450 to 474, is that inflation, or where does that number come from?
Could be a thing called CPI, I think.
Yeah, cool.
Yes, correct.
Which is part of the agreement. Councillor McDonald.
Thank you, Mr Mayor. Through you, perhaps to Seamus, just on page 2 of 9 of deed, item number 3.1K. 3.1K talks about to undertake on a project-funded basis specific economic development activities for local or state government in the region. I just wonder whether that should be broader than that and simply say for all levels of government. Give it the federal government may also have, and it's not restricting us to what that might be. The other one is, if I could refer to as supplementary, if I could, Mr Mayor, page 3 of 9, and it's more operational, I guess, than anything else, talking about 10.2. Company and council shall review the key performance indicators contained in the document entitled Funding Agreement Key Performance Indicators for Toowoomba and Surat Basin Enterprise before June 30 of each year, and any amendments to the key performance indicators or will be adopted by agreement of the parties. I'm just wondering, we have quarterly updates from TSBE. And just by way of this taking place, is council referred to as a council decision, or is it referred to as a delegated officer in council to review the key performance indicators on an annual basis?
Who's going to
Thank
answer
you
that
for
one?
the question.
Your question, not a comment. That's all right. Just on various documents, or various spots in it, it refers to council. But there would be a delegated level of authority down to the minutiae of operating. Key performance indicators are a higher level and should come to council, and a quarterly report does deal with those key indicators. But this process, I'm assuming, would be at an officer level rather than a councillor level. That's my assumption. I could be completely wrong, but the wording council may mean something different to a reader of the document than someone else.
Brian will comment on that.
The terminology refers to council, but under the delegations that I have as CEO, I have the delegated, I could do that under delegation and sub-delegate that if necessary, and would do so unless council specifically required that it goes to council for decision.
So I gather, if I could have a supplementary?
Yes.
Mayor, thank you. So that's an opportunity when we have our quarterly updates from Toowoomba Strait Basin Enterprise to have a level of oversight onto that and feedback to the CEO if there are any concerns.
Yep.
That's the process?
And I would think our quarterly updates are a very special part of a relationship. And they give us a very clear message as to where they are at any given time. And
They do.
I don't think there's every entity that we have that gives us a complete quarterly update in the way that we get them here. Anybody else have anything to say? Councillor Von Hoff?
Thanks, Mr. Chair. Thanks, Mr. Chair. So, further to Councillor McDonald's comments then, given that we're talking about a specific amount here in this draft funding deed, is now the time to discuss financials?
Yes.
Okay.
With that.
All right. So then, and I know we've got the Chair and the CEO here, so maybe if there's a degree of granularity and we still have questions, perhaps they can be of assistance. So, Seamus, you talked about CPI, and I had a question about wages. So I hope my maths is right here. The first question, I suppose, is that does the 2020-21 budget account for TSBE account for increased staff numbers?
Sorry, I don't have the answer to that.
Would you repeat that question again, please? And
the-
you can get a bit closer to that microphone. I'm having a little bit of trouble hearing.
Is that any better, Mr. Chair? So the 2020-2021 budget, does that account for increased TSBE staff numbers?
Do they plan to increase TSBE staff numbers?
That's right, in the 2020-21 budget.
That's probably a question for, if I understand that I am able to include Shane or Ali to answer a question in a committee meeting. Just come over to a microphone, please, Ali.
He doesn't have the information at hand.
So you're looking for increased staff numbers for the coming year?
So so looking at the numbers in the budget and the past financial statement, we've got a ex-payroll salaries and wages overhead increase that I read year on year of 6.2%. And so I'm wondering, that obviously exceeds CPI. So I'm wondering, does that account for added staff members?
Yes.
That's a yes?
And I guess with the various projects they have coming and going, there'd be certain people move in for a while and they'd head off. They'd come in for particular tasks. And I'd imagine that may well just reflect a period where things are on the rise.
Mm-hmm.
Needs to come to a microphone.
John had to come up here.
Maybe come down the front, Ali, if you would, please.
So yes, we will be planning to replace our COO. So that won't be. So her role was empty last year. So we'll be replacing her this year. So there are slight increases in a couple of wages because of roles that have changed, but the majority will be extra staff.
Okay, thank you.
Okay. Yes.
Right
around, Ali, please.
Supplementary question. Looking back at the financials from 2018, 2019, 2020, there's quite a degree of variation year on year. And I'm wondering, first of all, for an understanding about what accounts for that variation. And I can give specific instances if that's required, or otherwise it can just be a general statement. And then further to that, if this is a 3-year agreement and it's indexed according to CPI, given those historic fluctuations, how can we be confident that they'll start to level out and there won't be such fluctuations? Because otherwise the CPI increase would make, it sort of doesn't gel with what's historically been the case.
I guess I'm not entirely comfortable to answer that, and I think Ali would be better positioned to. But I would assume that that's based on the projects, the additional funding that TSBE receives from external bodies, and that comes with expectations and requirements and resources. But I'll let.
Yes, Seamus is correct. So the variation tends to be in projects. So, for instance, we're doing a project now for the federal government in terms of we've got the SQ Export Hub, and so that is extra funding. So that's distorts the figures. But your question around the CPI increases, I'm not quite sure what you actually mean by.
Isn't that's included in the deed? That
Yes,
would be.
I know about the CPI increases, but I'm not sure how that relates to the fluctuations in TSB's revenue.
So if we are agreeing to standard CPI increase for the next 3 years, and give or take a few percentage points, percentage points, that's very stable. I'm basically wondering how it would work for TSB when that funding is set, and yet there is those fluctuations and variances year on year.
With the variations due to projects, so those projects enable us to put on extra staff, and those staff are only on for that particular period. So the funding that TSBE receives from TRC is constant, which is perfect for the base level of TSBE's requirements in terms of our revenue. So basically the extra funding that we get, which makes the figures go up and down a little bit year on year, that allocates. So the funds that are allocated to that go towards staff payments and all sorts of other things. So the consistent funding from TRC is really important for our consistent delivery to our membership. Does that answer that?
I think it does, thank you.
Okay.
Any other questions?
Mr Mayor, if I
Councillor
could
Taylor.
ask what the Western Downs contribution is now to TSB. I know it went up. So
It has. Look, that's commercial in confidence.
Okay.
Confidence. Sorry, I can maybe say that.
Well, no, we're in a public meeting,
Yeah.
so just, yes, sorry. Thank you.
Yeah.
I've just forgotten, thank you.
It's substantial, and it's a recognition of the work that's being done.
It's very good to see that increase
Yep.
from there,
Well,
because
takes a bit of
quite
the
a lot
weight-
has
takes
been
weight off
done
us.
out in that region, which benefits us all. I agree.
Councillor Carl?
I wouldn't see it as commercial in confidence, given that it's on financials and it's in a public meeting and open to scrutiny now. That would, to me, not be confidential information. I stand to be corrected, Mr. CEO.
Well, if it's in the
It's not in our
financials
fin-
of the
it's not in our-
organisation, I guess it will come out being a
It's not
public
in our
organisation.
financials, so we normally roll up our grant funding, so it's not separated.
So, Mr. Chair, if I may, therein lies my concern. I'm not altogether happy with the delegation of the funding agreement to the CEO, given the report we had before council earlier in the day around controlled entities and the recommendations about a greater levels of scrutiny that needs to come directly from this boardroom around the future business of controlled entities.
Point of order, Mr Mayor, that policy hasn't been adopted and nor is it out in the public yet, and that would be dealt with in due course if that was adopted, and I don't think it's relevant to today's meeting.
I'm sorry, I beg to differ. It was in a public meeting. It was a public on the agenda, and I simply make the point that I'm not happy for the review of the next 3-year funding agreement to be delegated to the CEO. As per that report, which is public now, it's in a draft form, yes, given that I simply make the comment that it would be prudent of this council to actually go through that in an orderly manner.
Want to comment on that, Mr CEO? You don't have to. It's my understanding that the agreements we've had with TSB have always come to the boardroom. Now, I might have missed something, but I think they've always come to the boardroom for final approval, and that's the way it's run here. Councillor Summerfield.
Mr Chair, I'd like to move the recommendation, and in doing so I'd like to congratulate and thank TSB for all the efforts that have happened since it was initially founded, and I think it brings a lot of economic stimuli to our region and other regions as well, and has been a real success story for this council in outsourcing our economic development, and I continue to support it strongly and thank them for their efforts.
Second.
Councillor McMahon, seconded.
Second, Councillor Summerfield.
Thank you very much for that. Anyone wishing to debate the motion?
No,
Councillor Cole.
No, not necessarily debate, but if I need to, for the formality of the meeting, I'll speak against in the fact that I won't be voting to support the funding agreement, given the calibre of questions that have come and the lack of quality of answers. And I do agree.
Could you just repeat that last little bit, please? The lack of quality answers?
Yes, around some of the content on financials, and also I agree with the sentiments of Councillor Taylor, Carol Taylor, in that whilst some may feel they are full bottle on TSB and the operations, it would be nice to actually be refreshed as an pre-existing councillor around the funding agreement, and for those who haven't been around the table, have some of the history of how it's come to being, how it's evolved, and how there's been many changes along the way. It would be nice. But that's the reason why I would vote against it at this stage.
All right. Well, is anyone wishing to speak for the motion? We've gone backwards here. We've got Councillor Cole spoke against the motion for a start. Councillor Taylor?
I want to speak for the motion, Mr.
You want to speak for the motion?
I do want to speak for the motion, and I endorse the great work that TSB's done, but I also believe that we still should have a session with council and refresh and go over those things as well. Now, this is no reflection on TSB and the work they're doing or anybody involved with TSB, but it is our organisation and we are the council, and we should be well over it, and we should be able to have that without any thoughts against it. But at the end of the day, this is an endorsement. This comes annually to us, and it's an endorsement of the work they're doing, not only here, but also out in the region, which, as I mentioned before, does benefit us because we are, you know, the city is the lead city. And with those few changes, like with local, wherever Tisby is, and that's one thing we could work out if we had a session. If they were out in Roma, or if they were out in Dalby, they could actually try to deal locally there where they should. But other than that, they've done amazing work. It keeps expanding. We keep having new benefit coming in here, and there's a great opportunity now with the COVID for the freight planes and whatever that have been going out of our airport. So I think that there's been a great achievement here, and I'm speaking for the motion, but I do want to have a session on it. Thank you.
Yep.
And if I could, Mr Mayor, we actually are able to do that under that recommendation. We are able to do that under that recommendation because it authorises the CEO to execute the new deed, but it means that we can have an information session beforehand.
And, sorry.
Councillors, I just need to correct that. That recommendation, if you read that, it's locking me into agreeing, authorising me to sign the documents in attachment 2 and attachment 3. So that's the funding agreement and the performance indicators. So by adopting that recommendation as it stands there now, I would move from here, I would use those documents and I would authorise those in conjunction and execute those in conjunction with TSBE. So it wouldn't come back to council again.
Well,
So could I recommend an amendment then, please, that we do item 1, which is the funding, and item 2, that the deed come back, because the item 1 gives reassurance to TSBE that they will get their funding. But item 2, that prior to, yes, thank you, Wendy.
Okay.
Thank you.
That a workshop is.
The mover and the second be prepared to accept that as just a slight variation in the original resolution. Is that okay, Mr CEO?
Sorry, I just missed that.
I just said, would the mover and be okay if the mover and the seconder accepted that as a variation to the original motion? We can go through whichever way you like.
Yeah, this is committee. We just got to agree on a committee recommendation at the end of the day here.
Needed to be written first before I second.
Yes, we just need to get it written first.
So, Councillor McMahon, you're happy?
No, we've just got to get it written first.
I know, but you'll be happy to change that?
Yeah, but I'd like to see it before I second it.
We'll give you a moment.
Very short and sweet.
Right. That's the changed resolution. Is the mover and the seconder comfortable with that?
Well, we haven't mentioned that we'd workshop it, have we?
No, we'll do that. We'll undertake.
Well, and
Is that necessary?
very,
It's up to the CEO, probably.
Councillor Taylor, I can't hear that.
Sorry, Mr Mayor, do we need to mention that, or is it just, yes, okay, thank you. Councillor Summerfield? It's your motion, so you need to.
So you say we don't have to mention that? If we don't, I'm happy with it, so long as it happens.
Okay, we have a mover and a seconder. The motion is before you.
Just put the word proposed in there.
Adopt a proposed funding deed and associated TSB key performance indicators at a future council meeting.
So just a question through you, Mr Mayor. Does that, should we mention in there that council have an information session on it? Because I think that
There's been an indication from the General Manager that he will arrange an indicator about that, but if you want it formalised,
yes, thank you.
if it's appropriate to formalise it,
It's up to
Nancy was asking.
I'll give you an undertaking that we'll do that. We'll.
right. Anything else? If not, I'll put the motion. It's before you. Those in favour? Those against? Councillor Cole, your vote will be recorded. Thank you very much. Move then to the second item.
Where's Andrew?
Give her a break.
Andrew. Second item relates to the Bridge Street Quarry Development Advisory Committee. I'll pass over to Andrew.
Sorry, Mr Mayor, may I just ask a question before we go too much further?
Having trouble hearing you with the other noise.
Oh, really? Is that better?
Good.
Yep. Just a question before we go into the next session. I'm really sorry, Andrew, but I just wanted to wait till everyone exited the room. And I'm not too sure if this is the correct way to bring it up, but if we're going to have an information session on TSB, which is an owned entity by TRC, then we shouldn't single them out. We should have an information session for all the new councillors on every owned entity.
Comfortable to do that. And we've already had a quarterly report from TSB in this term, haven't we?
That's exactly right. So if we've had a quarterly session from TSB and we've had them from the other, I don't understand why we need an information session just on TSB. So if you're going to have an information session on TSB, then you need an information session on every owned entity, not single them out.
And, Mr Mayor, I agree, we probably do. Thank you.
Councillor Cole.
I'd suggest it'd be good practice in light of the draft policy before us earlier this morning.
Okay, we can certainly arrange that on all the entities that we have. You're happy that that discussion is okay now? The CEO has indicated he will do that. Right. Well, Andrew, over to you.
Good afternoon, councillors.
Saying good afternoon, sorry.
Yes, so the purpose of the report is to present the revised drafted terms of reference for the Bridge Street Quarry Advisory Group following the council information session which was held in June of this year, to seek council adoption of the terms of reference for the establishment of the advisory group committee, to seek council endorsement to call for expressions of interest for the Bridge Street Quarry Development Advisory Committee. This follows the session in June when we originally presented a terms of reference for a working group, and council recommended that that be changed to an advisory committee, and also recommended changes to the membership as well. So those the attached terms of reference reflects those changes to the membership, including seeking representation from each of the community groups listed, additional council representation on the advisory committee, and also residents of from Bridge Street within the area impacted by any future redevelopment of the quarry itself. And we also looked at changing the frequency of the meetings to at least meet monthly. Originally it was quarterly. So in terms of the recommendations, the report recommends that council adopts the terms of reference for the advisory committee, that council nominates a councillor to be the chair of the advisory committee, and that council also considers nominating an additional up to 2 additional councillors to represent council on the advisory committee, and that council approve the membership and expression of interest process outlined in the attached terms of reference.
Any questions around the room? Councillor Summerfield.
So I've got a number, if I could. Thank you for that, Andrew. So just on the first page of the terms of reference, under purpose, it says the advisory committee is to provide high-level leadership advice, directions and recommendations. Directions should not be in an advisory group. They only advise, and I'd like to see that word removed if possible, please. In relation to the membership, the person in Bridge Street, just can't see where that is at the moment, but it says resident of Bridge Street, east of Mackenzie, also has Redwood and Prince Henry Heights in it. We actually agreed resident of Bridge Street from east of Mackenzie through to before the quarry, because they're the ones that are going to be impacted. And so it was the only residents living in Bridge Street from east of Mackenzie through to before it gets to the quarry. So it would be only those people that would have the opportunity to be on that.
Okay.
And that was what we agreed to when we did the workshop, to ensure, and after a lot of discussion about what it was going to look like, that's what we ended up agreeing to. And we said that if we couldn't find someone on Bridge Street that was prepared to put their hand up, that we might expand it out further after that point. So if that could be changed, please, and that we also agreed that we would write to them. That probably doesn't go in the terms of reference, but we agreed that we would write to the residents in Bridge Street in that particular area rather than just rely on an advertisement in the paper. So all the residents in Bridge Street from east of Mackenzie through to the quarry. And then on page 5, down the bottom it says needs advice from ISG for the relevant quarry legislation. Will that come to this, will that be in that document before Tuesday's ordinary meeting, I wondered?
Sorry, I didn't catch that, sorry.
Yes.
Would you repeat that, Councillor Summerfield, please?
Sorry, on page 5,
Yes.
relevant legislation, there's a highlighted area there that says needs advice from ISG on the relevant quarry legislation. Will that information be in there by next week's ordinary meeting to ensure that it's complete?
Just a question there, wouldn't you just have quarry legislation and then out of that, for councillors' information, what it actually is? Because you haven't got the Local Government Act or anything else in detail there, it's just written,
I'm
recognised.
just asking, it's highlighted there, and I'm just asking, is it that's going to be completed by next week's meeting?
Yeah, sorry, ISG did provide the relevant legislation detail. I think it's certainly in my report. So so it falls under the Queensland Mining and Quarrying Safety and Health Act 1999, and also the Queensland Mining and Quarrying Safety and Health Act Regulation 2017. That the council can rehabilitate the quarry without approvals.
Any other questions around the room? Councillor McDonald.
Councillor Taylor, Councillor Carroll was before me, Mr Mayor.
Oh, sorry.
Thank you, Mr Mayor. Thank you. Just like to know how we're going to decide, or how you're going to work out whether you're going to have TSBE or the Chamber. So we've got one from those two groups. How is that going to be worked out? I don't think that's actually workable.
We followed really that it depends on the position of the quarry. So at the moment we're in a position of trying to find funding for the quarry, so council has committed resource, and TSBE might be a more appropriate vehicle to help us do that initially. And then as it moves towards or development on the site, then the Chamber of Commerce, through its connections with local businesses, will help us ensure that procurement stays within the region.
Thank you, Andrew. Yeah, that explains it to me. That's all I'd forgotten though. Thank you.
Yeah, the Chamber have been a parking place for some of the funding that's come in, I'd imagine, from the state government. They've been certainly coordinating it to some degree with travelling overseas and whatnot. Anything else? Councillor McDonald.
Thanks, Mr Mayor. Through you to Andrew, perhaps, or Stuart, or really just a comment for councillors to consider, talks about, on the second page, I think this is, page 2, 4 staff members nominated by the Chief Executive Officer reflecting the scope of functions of the advisory group at any point in time. And Councillor Carroll, I'm just reflecting on how RAPTAC has been used in the past when we've had officers from particular areas in the meetings as required. There's one glaring area of council that's not in there in water and waste.
Yeah, exactly.
And I'm just wondering whether it may only be for staff members nominating, but fair, we need each
We should have it.
area of council at least, and whether they're a nominated person or they're called on, and maybe there's the wording is that staff, as appropriately required, are invited to attend as experts in their field.
Subject matter expert.
Subject matter experts. Thanks, Councillor Carl. I just think we might be bogging it down, because I do think water and waste should be part of it, but then it might be part of that meeting may have nothing to do with water and waste. So I'd hate to have someone from water and waste involved in a meeting when they're not required.
Yeah, as required.
As required. So I'm just wondering whether that 4 staff members should actually change to just staff members on subject matter relevant to that meeting are invited.
As required.
And then so that's one area. The other one, which is around the chairperson and councillors, and it's probably reflective of my comments there in regard to this really is an all-of-council approach, and it will touch on each area at some point. And I'm just wondering if we go by that my mantra before, I'm wondering whether a councillor should actually be, from each area, should actually be on that advisory, because it may help inform the department in regard to the next meeting is X, Y, Z, and it'd be great to have so-and-so from water or so-and-so from waste involved. So I'm proposing, councillors, therefore, that there is a chairperson, but there is 4 additional councillors. And the reason I say that it's quid pro quo, because we're not subjecting officers unnecessarily to the meetings when they're not required, particular meeting. So if you go, Stuart, you look perplexed, which is fine.
Just thinking of the size of the...
Well, I've reduced with my previous dot point, hopefully, by way of subject matter only being there. But I'm very conscious of the legacy that this project could leave, good or bad, if we don't have enough input from elected representatives at this meeting, particularly in the first case. In 12 months' time, this might change completely, but I'd be inclined to have a representative from each in that. That's only my view in the early stages. One representative from each portfolio, and if that's the case, I'm happy to nominate Councillor Shine from ours to be our representative. But I just think there's value in that.
I agree.
Councillor McMahon, then Councillor Taylor.
Thank you, Chair. In regards to Councillor Jeff, great idea. We did go from one representative from either Quarry Gardens Mountain Bike Escarpment and Bushwalking. Now it's all 4 of them. You know, there's 11 in this room, and it's slow moving. So I'm just concerned about the size of this group.
And I fully understand that we've been in meetings where they've had more than this involved as well. I just think that the level of public scrutiny that could well be on this, and the input into this room and outside of this room may be beneficial. Now, all councillors may not be able to get to those meetings as well. And that's happened, hasn't it, Councillor Taylor, where we haven't been able to. But I think there's preference. Well, that's my view, that we could have 5 on there and reduce the specifics of 4 council officers of being there, just subject matter.
Councillor Taylor.
Thank you, Mr Mayor. Could I suggest that the councillors might revolve, I guess, the way the actual staff does, and say in the early days with the mining and other things, that it be, you know, that ISG might be front and centre, and then as it touches water or whatever else. I mean, I would see no reason, and as long as we communicate with each other, I would see no reason for all of us to be there all the time. And I think that that's probably a really good idea, not to exclude anybody, but as long as we keep each other in the loop, that it, has importance with the staff that councillors could drop in and out
Sure.
as well, I think.
So I'm just saying, one councillor as chair and then up to four additional councillors. And that way, they're on the books as being part of it, but as you say, Councillor Taylor, they may not necessarily be needed for that particular meeting.
Comfortable with that?
So therefore, if we're down to nominating people from Finance and Business Strategy Group, I'm more than happy to nominate Councillor Shine from my group, and quite sure other areas would do the same for their group.
Okay, well, we can do that down the track, can't we, rather than not today?
Yes.
It's included in today as well, in the recommendation.
Yeah, we'll just change the 2 to a 4.
So, Mr Mayor, could I make a suggestion? Would you say the chair or their delegate, which means that if you're not there, then you say who they are or whatever. I think that works better than putting actual portfolio chairs or their delegates, which is the portfolio leader. So you just work out who. And then if Councillor Shine can't go, then you might go to a meeting or something else.
So, the item, Mr Mayor, sorry if I could talk through that. Recommendation 1 with the changes that Councillor Summerfield's raised, and I think I had one there earlier. Item 2 is that council nominate a councillor to be chair. So if that's the case, I'm happy to nominate Councillor Shine to be the chair of that advisory committee. And then the next section is that council nominate up to additional 4 councillors to represent council on the Bridge Street Quarry, and take Councillor Carroll's comments, and it's a good one, in regard to perhaps portfolio chairs of the other areas, or their nominee, or someone else.
Depends how you've got your portfolio set up. I mean, I haven't got any things much, Melissa.
Sure.
So it just works out, you could work it out yourselves, between yourselves.
So maybe if we keep it broad like that, or I'm happy to nominate the numbers if that's needed as well. Names for the other.
Councillor Melissa?
Thank you. I do support Councillor McDonald's proposal of 4 plus the chair, and I'd like to, if possible now, put a nomination forward that I be on that committee or advisory group.
Would you like to what?
That's ISG.
More nominations for the committee, or?
Yeah, well, Councillor Taylor has nominated for one of the additional 4. So that's one, and that's representing ISG.
Well,
Councillor Shine would be representing Finance and Business.
So, this is a public meeting, and that's what I wanted to get away from. I think we should work it out between ourselves. I actually also wouldn't mind being on that, and I think that rather than have that out, we should work that out between ourselves. But I stand to be corrected.
Well, happy to accept the nomination of Councillor Shine as chair of the thing.
I'm happy to move.
Happy to move that.
Item number 2.
Item number 2, and that there be representatives of each portfolio.
So that council nominate, or council nominate.
Portfolio nominations come forward. Something.
Each portfolio.
Councillor Cole.
Yeah, in light of Councillor Tim's comments and the size of this group, look, I'm all for elected representation and always will be. However, given that it's an advisory group, I would have thought it had come back through the normal process and structure of advice to council, in council, given the significance of the project and the potential impacts, that council will make as a whole deliberations about that in the appropriate forums. So I'm just wondering whether we're doubling up on our efforts, or people in the room hearing the same thing twice. Whereas with other advisory committees, we go through a normal process of the committee comes back to council for determination and direction to the CEO about which way we go. I don't see this as any different. Look, I really don't mind either way, but I just raised that from an operational point that Councillor Tim's raised, I think, for the sake of know how hard it is with 11 people in the room, let alone what are we talking about now? So,
Okay, I'm in your hands. How you want to bring this forward?
Well,
I'm happy to move what it is, but, and from each portfolio, a representative from each portfolio other than, well, it won't be finance and business, so it's not each portfolio other than finance and business, because that's already taken care of.
Comfortable with that? With that wording?
And then portfolios can sort that out themselves with what it is before the first meeting, as Councillor Carroll mentioned. I'm happy to move.
You're happy to move that recommendation? Is there a seconder for that recommendation? Councillor Melissa Taylor. Anyone wishing to speak against the motion? If not, we'll close the debate. Those in favour? Carried without dissent. Okay. Well, I'll close the meeting and we'll go back to confidential. Councillor McDonald.
In favour? Carried. Okay, Catherine, when you're ready? You're ready. Thank you. Welcome back, everyone, to the committee. We have the recommendation there before you. We'll just put it up on screen. You might note that I've actually been saying these recommendations when they're short enough because those that are viewing don't actually see this recommendation, do they? Do they?
No, I don't believe so.
That council approve a 50% reduction in lease payable for the City Library Cafe and Encores restaurant for a 3-month period from 1 August 2020 to 31 October 2020. And number 2, that council approve a 50% reduction in lease payable for the Empire Theatre for a 4-month period from 1 July 2020 to 31 October 2020. Have a mover. Moved by Councillor Carroll, seconded by Councillor Megan. Those in favour? Carried unanimously. That concludes the finance and business. In fact, it concludes all committee meetings for today. Councillors, thank you, and thank you for your attention. The gallery, thank you media for being here. It's been great, and thank you to all of those thousands of people watching online. Appreciate it.